Court officer ಅವರೇ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ,
ಸರ್ ಹೇಳಿ.
ನಾನು ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಸ್ಯಗಾರ್ ಮಾತಾಡ್ತಾ ಇದ್ದೇನೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 17 ನಂದು.
ಹೇಳಿ ಸರ್.
ನಮ್ಮಲ್ಲಿ ಇಂಟರ್ನೆಟ್ ಪ್ರಾಬ್ಲಮ್ ತುಂಬಾ ಇದೆ. ನಾನು ಐ ಟ್ರೈ ಟು ಅಟೆಂಡ್, ಅದಲ್ಲೇ ಕೂತಿದ್ದೇನೆ. ಪಕ್ಕನ ಸಿಗದೆ ನಂದು 2 ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ದದ್ದು. ದಟ್ ಇಸ್ ಕಂಪ್ಲೈಡ್ ವಿತ್. ಕೈಂಡ್ಲಿ ಬ್ರಿಂಗ್ ಇಟ್ ಟು ದ ನೋಟಿಸ್ ಆಫ್ ದ ಕೋರ್ಟ್. ನಾನು ಇದು ಮಾಡ್ತೇನೆ.
ಸರಿ ಸರ್, ಆಯ್ತು.
2 ಮೈನರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, 2 ಏನು ಡೇಟ್ ಕರೆಕ್ಟ್. ಹೌದು, ದೇ ಹ್ಯಾವ್ ಬಿನ್ ಕಂಪ್ಲೈಡ್ ಆಲ್ರೆಡಿ.
ಆಯ್ತು ಸರ್,
ನಾನು ಹೇಳ್ತೇನೆ ಇದು ಕನೆಕ್ಷನ್ ಸಿಕ್ಕಿದ್ರೆ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ಥ್ಯಾಂಕ್ ಯು. 17ನೇ ಮ್ಯಾಟ್ರು, 17.
ಎಸ್ ಸರ್, ಗೊತ್ತಾಯ್ತು.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Detailed affidavit ಹಾಕಿಲ್ಲ.
ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ತರ ಆಗ್ತಿದೆ.
ಹೇಳ್ತಾ ಇದೆ ಏನದು
ನಾನು ಡೀಟೇಲ್ ಹಾಕ್ತಿದ್ದೆ ಮಾಡಿಲ್ಲ ಆಮೇಲೆ ಡೀಟೇಲ್ ನಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ. ಮಾಡ್ಕೊಡಿ
ಇವಾಗ ಅದನ್ನೇನು ಪಾರ್ಟ್ ಆಫ್ ದಟ್ ಐಯನಾ ಅಲ್ಲ ನಂಬರಿಂಗ್ ಇಲ್ಲ ಅಯ್ಯ ಒನ್ ಆಫ್ ಡೀಟೇಲ್ಡ್ ಅಫಿಡವಿಟ್ ಕಂಪ್ಲೇಂಟ್ ಹೇಳವ್ರೆ. For order, Samba 1, Sri M.M. Swami, Sri Srimati K. Vidyavati.
Lord, I pray for a week's time, Lord, to do the needful. Pray for a week's time, Lord.
Samba 2, Sri D.C. Sitaram Rao, Sri Shivakumar, Sri
Lord, I appear for the appellant in the matter, my lords.
Sri D. Sagar.
The required format, the reasons stated in the affidavit. The respondent, second respondent, is without his pension, he was refused from service. We are saying that it should be heard. What we do here, we should not be heard.
Number 3, Sri H.T. Natraj, Government Advocate.
You are fine. Everything is over here. You should tell us what
The mandamus were directing the respondents that to provide the water facilities for drinking and not that has been done actually. We have filed the status report. And pursuant there-
Mind of
Number 4, Sri Sridhar Prabhu, Government Advocate. CP Prasanna Kumar.
The issue is that they have, the committee had recommended, state finance commission had recommended had prepared a report that was to be tabled. The recommendations had to be adopted. I will apply to all the objections for these complaints. Yes. 10 days. Okay.
Number 5, Sri Srinivas V, Government Advocate.
Looking after the elevator. You should be happy, right? No. Actually, order dated 11/8/21. What is the order? Now, what is the order? Just what is this order?
But in fact, the elephant was in a good condition. You are in spite of it. They are taken. You lordship may kindly come to annex your bill. I hope it was right.
What is your grievance? Just forget about that. So what is your grievance? What has been done to the elephant?
It was in a temple, and the elephant, though it was in a good condition, there was one petition was pending. The dishonorable court have directed, but the order of worship may kindly come for a while at page number 18, Lord. In view of the aforesaid admitted provision, that before declaring that the temple to be a declared institution, the procedure prescribed. I am the Lord. We are managing the temple. Lord. This is a GM forest. GM forest.
Okay. So.
It's not a dedicated distinction. But we were managing the temple, Lord, and in the meantime, they were trying to make it as a this temple as a. They wanted to bring the temple within the Karnataka Hindu religious and institutions, and that was called in question before this honorable court. And the Lordship was pleased to pass an order that in view of the you are raising that I mean, because since it's the state of orders, I'm not fully thoroughly ready. You are not ready. I'm very sorry. Very sorry. I'll amend and then you go.
Just see is like managing the private temple. Data is taken over that temple. There was subsequently we have written a complaint that even this elephant is not properly maintained. There are 6 months today. Recently, would you have to maintain an elephant? Government has come forward. Will you maintain?
There are experts on the other.
Welfare of the elephant, right? Yes. I don't think what is the monthly expenses of the elephant in maintaining one elephant? What is the why don't you contribute to the government? Public spirited individual, you are a this thing activist wanting welfare of the animals. So why don't you do these people should
Managing
no, no, this is-
we are managing temple Lord. We are managing the Chowdeshwari temple and the temple Lord. It was,
all right, so in
used
any
for
case,
religious purposes.
all right, yes, you are all right.
And now not.
No, this see.
And public spirited person is respondent number 7, who has to be impeded. Unfortunately, I am not impeded in the work. It's a stage now.
No, he is concerned with the elephant. What he is the guardian of elephant?
He is concerned.
How?
He wants the elephant to be retained in the temple. He is actually supporting the
No, you can't. I mean, there have been so many people supporting. So will you impede them? That's not the ground, right? Of impediment.
In fact, application was allowed. I have opposed the application, but in fact, I am sorry, I didn't oppose it.
See, those people are calling you. What happened to our case? They are trying to find out what has happened to our case. Yes.
Like today, our merit price are large. On merit, I argue the matter. Because that is what the case is pending before the Endowment Commissioner. And the case is disposed of, my friend cannot maintain all those things now here at this stage.
All right. Yes. Please. He wants time. Yes. So this was done in pursuance of a communication sent by the Chief Executive Officer, Mr. Yes. This order was passed. What is the date of the order? Which is impugned in this petition? 11/8/21. This is Chief Executive Officer of the temple itself has sent a communication.
No. Chief Executive Officers of the temple have not sent it to Lord.
Yes.
There is a dispute between the brothers.
Fine. This is what.
Brother,
This is what they're this thing. Yes. This petition in this petition. Nothing. We are granting adjournment. But since we have spent so much of time, we want to write something, right? We are granting you adjournment in this petition, comma, the petitioner who claims to be petitioners who claim to be founder trustees of Sri Kalika Durga Parameshwari Temple, Vidya Narayanpura, Bangalore, have sought a writ of certiorari seeking quashment of order dated 11/8/2021. Full stop. Mr. Learned Additional Government Advocate, Mr. Patil, Learned Additional Government Advocate submits that the Chief Executive Officer of the temple, by a communication dated 29/12/2020, had requested the respondent number 5. Who is respondent number 5? Principal Chief Conservator of Forest to take possession of the elephant of the temple. Pursuant thereto, the impugned order has been passed. It is further submitted. That in compliance of the aforesaid order, the Forest Department of Government of Karnataka has taken over possession of the elephant and it is has been put in Malur Wildlife Rescue and Rehabilitation Center. In view of aforesaid submission, Learned Counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. List next week. Come ready, Mr. Nothing. No. We do it whatever, but you should be happy that elephant is at safe place in Malur.
Wildlife Center,
Right, Mr. Please come ready. come ready. Don't make a half-hearted attempt. We have adjourned it at your instance. Don't do argue. And seek proper instructions and argue.
Please, Ahmadullah Sharif.
6.
Number 6. Please, Ahmadullah Kutwa.
There is the petitioner in 6.1.
That's district convene. It has been challenged or challenged. Oh, then it should go before some other bench. Let shall be listed before a bench in which one of us write my name is not a member. I was a member of the committee, chairman of the committee who has made selections, right? So for a reason we are, you did not tell us. Huh? No, I am recusing myself. I should give a date, right? Just to, I mean, otherwise we can hear, right? I mean, there are, why to get into it? That's why we have, there are judgments and judgments. Administrative side, we may decide, but on judicial side, we can also decide. Administrative side, we take decisions, but we don't want to give a scope to any controversy. Why? That's why. So you make a request to register judicial. Bench will have to be nominated. Yes.
Number 7. The Alvin Sebastian.
Petitioner, my lords. I'm hearing for the petitioner.
Mr. Mahesh filed a memo. He's permitted to retire. What is it? Yes, Mr.
My lord, the petition is in relation to rehabilitation of an elephant Lakshmi, which was in the custody of respondent numbers 4 and 5. The state government as well as the respondent have filed their objections as well. Your lordship, it so happens that the elephant's present medical condition is poor. In fact, in the respondents in the objections submitted as well, the temple have stated that they do not have the facilities to take care of the elephant.
Yes, madam.
The elephant is in the custody of the respondent 5 lot, 4 and 5.
So
We would be happy if the division is allowed.
allowed.
We would take the elephant and then put it in the.
So who appears for 4 and 5?
None appears, my lord. They have filed their objections, but nobody is appearing.
4 and 5. You have filed a memo. 4.
The Abhinava.
Let's see. So, you are happy to have the elephant, right? Okay. Yes.
Okay. The MP Amritavarshini, government advocate, the MP Geeta Devi.
What 801? Hmm? 80? No. 20. Why? Huh? Hmm. Yes, madam, any objection? Market presence learned counsel for respondents 1 to 3 submits that this petition be heard analogously with CC number 801 part. This for analogous hearing in the next week. Oh. Oh. Yes.
Padmanabhar.
Yes, Mr. Thank you. Learned counsel for respondent praise fund is granted weeks time to enable him to file an affidavit of compliance. Understand? GM Srinivas Reddy, BJP.
We already issued endorsement not the respect of the representation and place it before the lordship may kindly have.
When?
Before the lordship. But
There was a direction.
Lord and Lord, the representation has been considered with endorsement dated 7/7/2022.
What do you want? How much? When will you place?
It will be filed today, Lord, probably lordship.
Right.
We have served on.
They stated that we give the representation on 14/3. It has been decided, right? Consider the representation 8 weeks. So what has been done? When has it has been decided?
Endorsement have been decided on the 7/7/2022.
7/7. Yes. You will have to challenge it, right? Mister, you will have to challenge it, right? This endorsement in a separate petition. What can we do? In a contempt, right? Willful disobedience. Where is the willful disobedience? No, no, you should have got an order. Should have, please understand, you should have got an order from the learned single judge that they are directed to allow your representation. Then they could not have done anything else except to allow. But this is to consider. They have considered it. Right? Learned additional government advocate press fund is granted a week's time to enable her to place the compliance affidavit on record. File an affidavit of compliance. 11, government advocate, H. Kumar Jain. You are for respondent. 11. Please come this side. Not filing. Yes. Yes, what is it, madam? What? No, you are ready, right? It says non-filing of objection, you are ready. Then say so. Say so. It's not that we should ask you that what will you do. Please tell us. I mean, you have from here, you have come here, but you have not said that I want simple one sentence. I want time to file objections to IAS. Good enough, right? So, learned additional comment for the applicant, Mr. Sukumar Jain, learned counsel for respondent praise for is granted 3 weeks time to enable him to file objections to IA 2 of 20. No, this is writ appeal, Mr. Which provision of law permits you to file objections to memo of appeal? Unheard of. Show us from Karnataka High Court Act. We will grant you 6 weeks time. Which memo of appeal? Objections to memo of appeal? What is it? Order to that effect. No, there can't be. Please tell us. Give him Karnataka High Court Act. Because it's an order. No, there can't be any order. I mean, if it is passed, you should know what to comply with. We will clarify it. We will clarify. Not take it. No. It happens by oversight. It happens. You know, you are the counsel. You have studied the law, right? You don't know that objection to memo of appeal is not to be filed. Statement of objection to the appeal. Any provision? No provision. Learned counsel for the respondent submitted that he be granted time to file statement of objections to the memo of appeal. In this connection, learned counsel for the respondent has invited the attention of this court to order dated 16th of March 2022 passed by this court. Paragraph. When a query was put to learned counsel for the respondent as to which provision of Karnataka High Courts Act 1961 or rules framed thereunder permit filing of objections to memo of appeal, learned counsel for respondent fairly submitted that there is no provision to file statement of objection to the memo of appeal. Full stop. Therefore, the order dated 16th March 2022, insofar as it pertains to a direction to the respondent to file statement of objection to memo of appeal, is hereby recalled. Now, what do you want? It is recalled now. File. Learned Counsel for Respondent submits that he has filed objections to IA 2 of 2022. So that appeal has been admitted. There is a stay, madam. So what is IA 2 of 2020? You have not asked. This is the IA, madam.
But we are not pressed for this reason. Remand happened to the KAT.
All right.
Proceedings are
What
going
is-
on.
Oh. What do you want? What do you want? Madam, it's your IA. We have to pass an order. Choice is yours. If you don't want to press it, we will dismiss it. Why? No, madam, one thing, the appeal has it been received? Admitted? Yes, admitted.
Until I have finished the entire proceedings regarding the base of the.
Additional government advocate. Yes, what do you want? Please. Please. 50. Yes.
All the appeals, common appeals are made. Appellants, the responding to other appellants. The dispute was only with regard to fixing the price of the land. Land is held to the commission. Against which I prepared appeal before the creation, only pursuing the fixing of the rate. That in the order demanded, taking aside the rate with the direction to fix the fresh price. By demanding it, the disputed land is only that's why I'm reading order. All the appeals, operating portion, all the appeals are allowed. Taking aside the order, so far they relate to the market value of the land. From the included order of the appeal number, this is my appeal. 393/95 is also set aside in so far as relates to rejection of the prayer of the appellate from the grant of the remaining portion of the survey number 102/1 to the extent of 2.10 acres. Total land is 6.95. Out of it, 2.10 on rejected. Between the market as well as again redeciding the grant to the extent of 2.6. What state is seeking for the entire 695. In that extent, it will clarify.
One paragraph of the order and that's way to entire order. The logic would be the last 4 lines not in the very same page number. This is further directed to give an opportunity of being heard to the appellate in appeal number 2 regarding the grant of permanent ownership in respect of the entire land. Therefore, that proceeding is going on. Till that is done, the fixation of value will not be done.
Sitting is pending before.
Deputy Commissioner.
20 years. It was pending for 20 years. That's all observing the learning single teams. Even after this remand.
But this order of remand is there, right? Learned single judges remanded the matter.
Learning single judges directed to fix the price within 3 months.
Oh.
In that period, nearly 20 years it was pending, my lord. That's what it was observed in the order also. That usually fixed remand also. As far as 2 acre can send for him to retranslate the grant. Remaining 4 acre 95 cents, he has to fix the.
But appeal has been admitted, right? The very same order by which you were granted time to. Appeal has been admitted for hearing. So what happens if they will have to fix the price? So appeal will become infructuous, right? So we will have to prevent them from doing so since the appeal has already been admitted for hearing. Please file an application for urgent hearing. We will decide it urgently. There's no problem, but the question is of stay. You're fine. Yeah. Heard on IA number.
We request for clarification only to this, not for the entire 6 acre vehicle, because 2 is 102 or 1 to the extent of 2 acre extensions, yes, they have to read it whether it should be granted or not.
Page
Page 50, I have read.
page 14. First sentence of the order passed by the learned single judge. Whole the dispute pertains to 6 acres, 95 cents. That's why. That's why heard on I. Heard on IA number 2 of 2022. Learned additional government advocate submits that in this intra-court appeal, the order of demand has been challenged and the proceedings are pending before the deputy commissioner. It is further submitted that in case the deputy commissioner passes an order of demand in pursuance of the impugned order dated 22nd February 2019, the appeal itself will be rendered infructuous. On the other hand, learned appeal correspondent submits that the proceeding for remand be stayed only to the extent of 2.10 acres of survey number 102/1. Paragraph, we have considered the submissions made on both sides. From perusal of the order dated 22nd February 2019, passed by the learned single judge, it is evident that land bearing survey number 210/102/1, measuring 6 acres and 95 cents, is in dispute. It is the subject matter of this appeal. Therefore, the submission made by learned counsel correspondent does not deserve acceptance. It is that the appeal has already been admitted for hearing. It is directed that during pendency of the appeal, the deputy commissioner shall not pass the final order in pursuance of the order of remand dated 22nd February 2019, passed by the learned single judge. Accordingly, IA number 2 of 2022 is disposed of. Like,
Another writer.
notices issued, have been served, not filed. So when the notice was issued,
Now they're going on with the land space law.
all right. That's what contempt is about, right? Despite service of notice, none has appeared on behalf of the respondent. Let a bailable warrant in the sum of ₹10,000 be issued to secure the presence of the respondent before this court on July 2020. List on 19. What office objection? No, office objection. What submission?
Parties who are in the review petition for the undertaking, they deliver the property in the time limit. Petition number 1, complaint number 1 and 2 are the parties in the review petition. That was the undertaking given by respondent number 1 and number 2, page 94.
What have you done? What is the object? Please tell us if the senior counsel is appearing. Your colleague appears in final hearing, you appear. Yes. So what is it? What is it?
review order in the review petition says.
What is the, listen, close the file first. Tell us what is the office objection.
Office objection is petition number 3, complaint number 3. Advocate. He cannot be party 1. Second office.
Why? Why he cannot be party?
Because he is not a party to the proceeding. Party to the proceeding.
So why have you pleaded him?
Because he is the advocate who has been, he went along with the process court again for the execution proceedings for handing over the delivery. At that time, that advocate is also assaulted with respondents. Court again is returned.
Advocate has assaulted.
An advocate is assaulted by the accused person. Advocate, along with the landlords, freeholders, went to the spot. In
So it is assaulted means he is assaulted means independent cause of action. Somebody assaults someone. What is the offense?
Yes.
Right.
Somebody assaults somebody.
Get a file FIR.
Yes, but he is a case.
No, but who is complainant number 3 is who have been pleaded, who is not a party to the proceeding.
Number 3 is the advocate for the degree holder who goes to the
No,
court.
that's fine. But how does he get? Has he purchased the litigation? Subject matter. Well, so how can you, Mr. That is, we understand that it is a whatever is unfortunate which has happened. How can you file a contempt petition?
Delivery my lord, delivery order, it's certainly a contempt my lord.
No, contempt means that's why 1 and 2 who are parties are prosecuting.
Yes.
So, I mean, how can an advocate be permitted to?
The advocate is also assaulted. He also
Advocate is assaulted. Offense under sections depending upon nature of injuries. It's 324, 325, 323, whatever. We don't know.
Let it not go further.
Or 307 also. We don't know.
So on the advocate who is on duty, my lord, is also clear case of obstruction of duty.
Is the obstruction? No obstruction. Mr. But you cannot join hands with litigants, right? And follow. That's why. We have got your submission, right? So therefore, he is assaulted. Therefore, he is complaining. Just therefore, he is complaining number 3. What is the other office objection?
That opposite one is complainant, 1 and 2 should not have a party. Then is person who assaulted him is also not a party. The proceedings. That he cannot be arraigned.
Who has assaulted him? What else? What it? So accused number 3 cannot be this thing included. And what is the other objection? No, 2. There are 3.
Other side,
1, 2, 3, along with submission. Third submission. Third office objection. No, there are 3 office objections. This thing. Please give him the call this senior counsel. Give him. Please see. You have not been properly instructed by your colleagues. Third office objection.
That GPA holder cannot prosecute.
Third office objection. Who is GPA holder?
My lord, in the review petition, my lord. In the review petition. Point number 1 and 2 are the husband, wife, landlord who are represented by the GPA holder. Complaint is also filed before this honorable court by the GPA holder representing the.
We didn't get it. Who is
Number 3 is
GPA?
rectified. Objection number 3 is rectified. Yes.
What is objection number 3? What is 3?
That VR Prakash has been made a party, not proper.
Who is
Initially,
VR?
complaint was filed in the name of Amit Prakash is for a holder. It's not proper. So that has been rectified. My lord. VR Prakash is a party to the proceedings. Amit Prakash was not a party. He was only for a holder.
Gita Prakash, Gita Prakash. Oh, good.
Now it's amended.
What is?
It's corrected.
It is corrected.
You cannot only this point, my lord, as far as contempt of petition is concerned, my lord.
sending the lawyer to motion, bringing the kind of to the family court. This is a case where where the court process server has been also adopted, and including that weights and submitted the report. Under Article 215, this family court has the power even to take so much to proceedings against that person. And they will bring to the court. And this aspect may not that an advocate when he has gone to the court, he has adopted independent cause of action. That does not repeat.
Now, please tell us some case law that supposing the advocate goes for execution, he has the locus to file a complaint. Where is
1972, my lord, please.
So we will give you a separate cause of action, right? It gives you a separate cause of action. So then please file a petition in your capacity. Don't join with the litigants. 1 and 2 are litigants. That's what we are saying.
Not joining the litigant, it is making more under the court.
Yes.
Ask para, my lord. Para 8. If it is an IPC offense, it doesn't give an exemption from the operation, my lord. The contempt of court. Para 8. We find
No, we didn't say this. We didn't say that it gives. What we tell you. No, please. No, Mr. Hegde, please understand. What you are, please listen to us. What you are trying to do is that since the advocate had accompanied the process server for execution of the decree, he was assaulted. He has also filed a contempt petition. So please tell us any authority that he can also join he can file a contempt petition. That's what we want to do. So that's the office.
At the most, he can be a witness, like a process server.
Yes.
At the most, he can be a witness. You have not joined the process server as a party to this contempt proceedings, right? He was also assaulted.
Please, a very pertinent question. I have to answer.
In the same manner, he can be a witness.
There cannot be multiplicity of complaints. There can be only one complaint is one period. And second theory is, my lord, that others will become witnesses. This is the situation.
Yeah, that's simple. The query is simple, right? If he has been assaulted, advocate can file a complaint. Please tell us any case law. It doesn't say so. This is not an authority for this proposal.
It says, my lord, that says, it says IPC provisions, my lord, that fact that it's an offense of IPC doesn't
We did not say.
Applicability of the contempt of court act.
We did not say.
Please.
We would have, by now, we would have issued notice, provided you would have complied with. But the question is, please, no, please tell us. We are putting a question. You answer it, study it, examine it.
This question, my lord, that the advocate has
Yes, we want to know.
That exact question has not fallen for consideration.
No, please. We are asking you, make a research. Have you made a research?
Yes, I have made research. I have made research on this point. One is
no, there can't be any case law like this, right?
There cannot be any case law because but it means, my lord, advocate cannot come to the court when he is being advocate. There can be, my lord, which means advocates are excluded from invoking the jurisdiction of the. No, my submission is any officer of the court when he goes for execution of the.
No, so in all the cases, right, you are also an officer of the court.
Yes, I am an officer of the court. So if somebody has not a judge and somebody has not advocate,
just a minute. Why are you getting agitated?
I'm agitated because it's the question.
Just a minute. Just a minute.
The Lord may also kindly bear with me for this reason. I'm agitated for this reason.
No. You want to answer this query by reference to case law, or you are answering like that? We will decide it.
My lord, will definitely decide. Every case, my lord will decide. My submission is.
No, we want whether you want to make a research.
My lord, directing me, my lord, certainly.
No question of directing.
I have made.
No. We can't direct you to do. You are a senior. Just a minute. So listen. What is this? Simple.
Why should I meditate? I'm putting both.
Switch off the mic. So
sometimes mic is not required.
Not required. No. So you want to answer? No. We have.
No. There cannot be and the lawyers, the court officer, my lord, and train on the court, everything is fine. Calling the duty of the judge with the contempt action can be taken. And when an advocate on a court bail goes for execution of a court warrant, and if something happens to him, there cannot be distinction between these two classes. Both amount to, because until that court act doesn't make any distinction. As far as the criminal law is concerned, any person can get the law into motion. If by not, then only one person is sufficient. I will apply other things for witnesses. Well, of course, this is a case that bringing the order to the court. And whether this requires further deliberation or question, advocate can file a complaint. I respectful submission. This is general proposition. And as criminal law is concerned, any person can get the law into motion. And since the plea is not a stranger to the proceedings, he is himself a victim. This is question, my lord, whether there can be more than one complainant. There is no bar under criminal law, either under section 200 CRPC or under the rules framed by the Karnataka High Court and the contempt jurisdiction. This is a technicality which does not come in the way of taking action when there is an absent judicial system. An order of the court being executed has been stopped. So this subject objection will be very overruled. Notice will be issued. This objection has been like pleading defense. And article 193 consider the powers of the court. This is where we can make its report approved also. Written report. And written report is also reflected in the judicial order of the magistrate. Engage on I think that will be number 105 last and the government made it to selected by the court and that the report of the court can be selected by the court to the order. Part is court on plan on the court will completely take over the order. People take the one. At that time, why is it mentioned on the one and education plan to part of the intimidated and also exhausted in the order. Educated people came to the and also the second is that on in case of active execution, come there the court will return and reveal. There are multiple complaints are not made to be decided in the procedural aspect the case of the court defense. And this way, the issue for this.
Yes, next.
Number 14, Sri N. Damodar.
Appear for the petitioner in this matter, my lord. I pray for a week's time to comply the office objection, my lord.
Week's time.
Budget.
Number 15, Sri V.S. Venkatapura, government advocate.
Yes. What? Huh? What? Why are you not filing? Huh? When an additional government certificate this warrant is granted 2 weeks further time by way of indulgence to enable him to file compliance certificate.
Number 16, Sri Yasmin Babu, Sri Allah Bakshan.
Yes. Respondent number 2 has not been served, right? Non-filing of acknowledgement. Is it? Right, 1 minute, 1 minute.
So two people were associated. One of them is elder. So that's the argument is correct. Then the process server should also be correct.
But it's a PP learned senior counsel for the petitioner. Learned counsel for the petitioner submits that that he has submitted that he has filed that he has submitted a submission in view of the office objection. Full stop. We have perused the record. We have heard learned senior counsel and perused the record. This contempt petition has been filed under section 12 of the Contempt of Courts Act for non-contempt. He has filed civil contempt. This petition has been filed for this petition has been filed. This petition has been filed under section 12 of Contempt of Courts Act. The complainant number 3 is an advocate who is said to have been assaulted in the case of in the course of execution of the decree. The office therefore has raised an objection that the complainant number 3 is not a party to the proceeding of which the non-compliance is alleged. In case the complainant number 3 has been examined, he is at liberty to take recourse to such remedy as may be available to him in law. The office objection is therefore sustained. The complainants are permitted to directed to delete the name of complainant number 3 from the court cycle. The remaining office objections are ignored. Let the office objections be complied with within 1 week. List thereafter. Yes. Serial number. What? 1 lakh. Come here. Why are you standing here? Para? What is it? These are the areas of 2 lakh. 2 lakh. Where do we get this? The order. In the last occasion, I paid 1 lakh 5,000 rupees. And balance I taken undertakes 5,000. Along with that, another 1 lakh 40,000 and paid. What is the memo of calculation? What is the amount due from which period? Yes.
But is it serial number 17?
So, they have filed this thing, memo of compliance, the calculation. Where is it? When have you filed? 8/6. Have you responded to this memo? No. Fine. Your objections to you file also memo of calculation, right? How much time?
Taking the entire amount, my lord. Now they want after recovering the amount, my lord.
No, don't give the draft. Don't give. They want to litigate, right? He is not interested in the amount. He wants litigation. So we will hear. That's why we are granting you. Don't give the draft to the petition. Don't. We will have to decide this, right? Supposing if we direct you to pay the amount, despite that he will argue. So we want to ascertain how much is it.
That, my lord. And
you go approach the executing court, Mr. What is this? What is the what is this amount due means what? Under what? He has not told anything. Tell us under what provision, which decree what this amount is due.
For eviction was filed, HRC
Suit for
petition
eviction.
was filed. In the HRC, they said that there has been fraud has been played.
All right.
Then we filed an application and we entered as an objector. And
You are a tenant, right?
Yes, my lord.
You are
I am
a
a tenant.
So,
I am the LSS and the subtenant. The matter within the
All right.
report ended with
so
the
what
compromise
is the
petition.
dispute is for a period from rent for a period from which period to which period?
Now this is the
Which period? Dispute.
March 2020, my lord.
March to
6 months due, my lord. From there, 6 months due.
where is that?
To 2020.
No, yes, memo of calculation he says October 2009.
Now that is totally against their own petition, my lord. In the petition, they had said July 2021.
What is the rate of rent?
35,000, my lord.
35,000 per
Yes,
month. All right. So where is the petition? Petition. Their petition saying what you are saying, that contrary to petition means we will have to see the petition.
their own petition, my lord.
Where is
The page number.
compromise petition, right? Compromise petition is there on record. I share the-
Page number 40 is the compromise petition, my lord.
What is the agrees to pay a sum of rupees 9 lakhs.
9 lakh is the advance amount that we have paid, my lord. That is not in dispute. Now the dispute is, my lord, 35,000 rupees was the agreed rent as per the terms of agreement clause G, page 17, my lord. Page 17. G is the
Undertakes to pay 30,000 only per month.
no below the last third line, my lord. From 1,625 35,000.
1621, 323. 31st January 23.
35,000.
35,000. So what is this whole amount come?
Now, 2,10,000 rupees as per their own petition, pleadings our mention.
Where is that?
Page number 6 of the petition.
Page?
Page 6.
There is no page 6 here. It's all
Petition
20.
Petition para number 12, madam.
Para?
Para number 12, madam.
No 12. Which petition?
The content petition.
Consent
Content petition para number 12, madam.
Para 12. Yes.
Para 12. They invited to directly from the report, monthly meeting up to the report is India. And presently due for some of 2,10,000. In this number, 2,10,000 rupees.
2,10,000 was on 7th of 2022. Then this is now we are in July.
This number. Now I have paid where to dispute what they want to do is the running months spend they want to do that. 35,000 is what the terms of the compromise number. Now if that is taken into consideration, not 1 lakh.
No, 2 lakh,
40,000.
just a minute, 2,10,000 is rent for a period from which period to which period, Mr.
That is
According
stated
to
in para number 8 madam, of the same petition. But one page earlier.
Ah.
Just stated from July 2021 have not paid the rents.
July 21. It, July 21 till
That is not clear. They are not clearly in the petition number. But the total figure what just said it is 2,10,000 rupees. I get 2,10,000 rupees. The petition should be closed. I in fact
what is it? Yes, he has paid 2,10,000. Right?
2,10,000 for 6 months.
Proceed against him for willful and deliberate breach, which is the continuous liability on him to pay every month. It is not the fixed amount. As well as coming to the commission rate, so it's a continuous cause of action, right? Every month you can file contempt petition. Every month. The observation what is made in the order is to pay every month. As on the date of filing of the petition, it was 7 months since the order. You have said Mr. Para 12. What the 2,10,000, he has paid 2,10,000. Now you recover whatever.
If you rush him and come to pay 70 allotments,
Just a compromise decree is executable. Compromise decree can be executed.
please do that.
Please initiate.
Because
You can't every month. I mean,
just because the compromise decree can be executed, he cannot run away from contempt proceedings.
not running away. He has paid. He has paid 2,10,000. The question is whether we should act as an executing court in contempt proceeding. You in para 12, you have said 2,10,000 is due. He has paid 2,10,000. End of the matter. We cannot work as an executing, like some compromise decree will be passed by some court and High Court executes the decree, right?
Even if he pays 10,10,000 rupees, the other remaining months that he has not paid, that amounts to contempt. Again, you don't know.
Para 10, you have said 2,10,000.
You kindly come to my to page number 17 for a moment.
You file Mr. Statement of whatever objection. He doesn't want money, right? He wants litigation. You file this thing, your memo of calculation. How according to this thing? Mr. The memo of calculation, no full amount is disclosed. Like so we are supposed to.
Every month, what he has paid, I have stated on serial number 23, October 21, 2021, he has paid a lot. On 25 2020.
What is due, Mr. You should file a
from November 2020.
learned counsel for the parties are granted a week's time to enable them to file memo of calculation.
17, the Krishnamurti ji are there, the JP Sharad Toda.
Yes.
The Krishnamurti ji are there. Number 17.
He was asking, right?
Yes.
This ST was going on. No, not submission.
The
He was
Krishnamurti ji are there.
He was asking us whether it's item. number
I represent.
and when it
One
is
is
called,
regarding the
he is
correction.
absent.
Both are applied with. Both the objections have been complied with long back on around 10/5/22.
Learned counsel for the petitioner submit, appellant submits that the office objections have been complied with on 10/5/2022. Let the appeal be listed for orders on admission.
Number 18, Akash Kumar Gowda.
Granted to comply with office objections.
I think the Sudhindra, government educate.
Yes, please. Comply.
Here.
Where is that? Learned additional government advocate, learned Mr. Vijay Kumar Patil, learned counsel correspondent submits that the office objections have been complied with. He prays for and is granted a week's time to enable him to file compliance report.
20, the Siri Rashekar.
Undertakes to comply with to find the translated copy of these documents. What is it, Mr. What is the direct? No, this is contempt. Contempt, Mr. No, what is the non-compliance? No, what is not? The respondent has not complied.
Yes.
Number 21, the BS Nagaraj, government advocate.
Learned counsel for the petitioner shall file the counter affidavit to the compliance report during the course of the day, list after 1 week. But you file it there in the filing count.
Number 22, the Rangnath is doing government benefit.
Respond number 2, Deputy Commissioner, Mr. Patil. Yes. Why today? Yes. Copy. Give him copy. Give him the copy. Let him see. What was the direction, Mr. 7th, 6th July 2022, right? Endorsement has been issued now. What 3 weeks time? What objection? You will have, please see, that's why we are asking, don't seek that. What rejoinder? Please come to page 37. Page 37. To decide is a representation, right? The representation has been decided. If you are aggrieved, challenge it. What see we are seeing, you see it, you also see. 6th of July. What is this? Every case, Mr. No, there's no problem. No, just please understand, no problem. We can adjourn it to next year also. There's no problem, right? But this thing is, we want to tell you why we are telling you to go through it and you will have to eventually challenge is that you won't get any relief in this contempt. We will keep it. No. We will defer it for 6 months, right? It will come in the next year, January 23. No problem. You are only saying 2 weeks. We are saying we can fix it 2 years after. But after 2 years, you will have to file a petition again. Please understand. That's what we are trying. In contempt petition, we are required to decide whether or not there has been a willful disobedience. Direction to consider representation, that doesn't mean that it has to be allowed. Don't get such orders. If you want that your representation to be allowed, tell the court hearing the petition that please do not decide my petition, I will have to come again. So no problem. You file, we will grant you whatever time you want. We are trying to tell you. Perhaps we should not tell you because you are only interested in adjournment, right? Petition. What can be done? Fine. Need counsel for the petitioner. How much? Right? 4 weeks. You just now you said 2 weeks. Now 4 weeks. Nearly. No. What will you? Just now you told 2 weeks, right? The press fund is granted a week's time to enable him to file rejoinder, etc. No. What do you mean? No, we don't require your senior for to argue this case. This is our contempt. We will decide whether or not contempt is made out. You have your locus is over. You have brought it to our notice, right? It's not a writ appeal. Please understand. Just on 25th July. Learned counsel for the petitioner makes a prayer for after this court had fixed the date of 25th July. Learned counsel for the petitioner submits that the matter be fixed on matter be taken up on 29th July. The aforesaid prayer is rejected. List on 25th July.
Number 23.
We request for 2 weeks time to comply with the objections.
2 weeks time. What objection?
That's the objections. Look into the file because 4 days ago the appeal is filed. Not been able to go through the
paper. 2 weeks time. Yes, 2 weeks time to comply with office.
Number 24. The Anil Kumar, the Lokesh.
For 2 weeks. Yes, 2 weeks.
25. Srimati Sanjana PN, Government Advocate.
What is IA2 of recalling order dated 19/4? Officer, 2 weeks.
26.
2 weeks.
Direct time.
27 to. We have granted 2 weeks, right? We granted to the council just now. You heard 2 weeks. He was saying 4 weeks. So we are being magnanimous. We are granting 1 week. We are granting 2 weeks. Thank you.
27.
2 weeks. 2 weeks. Have you complied with? Complied. Learned counsel for the petitioner submits that he has complied with office objections. Office to verify and proceed. We have accepted your statement. You just said you have complied. We have said you have complied. What else? Nothing, no urgency. Nobody will be hanged at 2:30. Nobody will be hanged. What urgency? No, are you losing your life? What exceed? Mr. There are 3. Huh? No, so supposing if we issue notice today, it will be conducted today itself. Examination will be conducted. Why don't you comply? You have told us that you have complied with office objections. We have believed it. We have directed office to verify and list on whatever date. 13 July. 13 July is day after only. We don't know. We have. This is not fair. You said there's no question of argument. You said I have complied with office objection. We have accepted the submission. You are an officer of the court. You have told us that you have complied. So not complied with, right? What clarification? So what? Why? That means you have not complied, right? So, Mr. Tell us what are the office objections first. Verifying affidavit to be clarified. So then say so. Why did you say that I have complied with office objections? There are 3 office objections. You understand that. You are not that dumb, right? That you are deliberately telling us. You have not complied. You want time, fine. Learned counsel for the office objections also there should be an elaborate hearing. Learned counsel, yes. Learned counsel for the petitioner submits that he has paid the deficit court fee on when today. He has paid the deficit amount of court fee today. And what is para 3 in verifying affidavit to be clarified, which annexure is certified copy to be stated. You have to state, right, that whatever. Learned counsel for the petitioner undertakes to comply with office objection number 1 by tomorrow. And what about to be clarified? What clarification? And shall furnish a clarification with regard to accused number 2 and 3 by tomorrow. List on 11th July, 13 July.
28. Sri Bharat Kumari, Government Advocate, Sri Chandrappa.
For the petitioner, my lords. My lords, there is one office objection with respect to page number 42. That is a map which we have received as annexure with other documents from the state. We cannot file a translated or a typed copy of it. That may be overruled. We are not relying upon it.
The counsel for the petitioner submits that he is not relying on the map which has been produced at page 42. In view of opposite submission, office objections ignored. Also heard on IA 1 of 2022 an application seeking dispensation of production of translated copy of P, Q and Q1 for the reasons assigned allowed. Requirement of filing. You say requirement of filing the translated copy of annexure P, Q and Q1 is dispensed with in the result IA is allowed.
My lords, if I may submit with respect to the matter is this, my lords. My lords, by virtue of annexure C, in the year 2014, the petitioner filed for a grant of lease in respect of building quarry stones. And subsequently, from 2014, my lords, there were 3 departments of the state, that is the Forest Department, Departments of Mines and Geology, and the Revenue Department, to which these applications went. And as due diligence, they came, they did spot inspection. They have stated that this is not a place where it has been.
Mr. Notice has already been issued.
Yeah, they have filed their wakalat, my lords. 9 and 10 have filed wakalat. 1 to 8 is government. 9 have filed wakalat, 10 have filed wakalat.
Fine, so they have to file objections, right?
My lords, I am only seeking for the interim prayer of my lords stay or a status quo. For the reason is this.
We'll take it up day after tomorrow, right? Or what next week, whatever you want.
Day after tomorrow would be fine, my lord. There is urgency.
What urgency?
The urgency is this, my lords. The only dispute is.
Notice was issued on 19/5/2020.
Please. From that time, the dispute is.
What week's time?
Please, one humble submission, if I may make.
Please. Yes.
My lords, the dispute is page 62 may be seen for a moment.
No, Mr. It is for office objections. We have not gone through it. We don't know. And notice was issued. It's not listed for IA. We will list it on Thursday for IA.
Please, Thursday.
Let the rate petition be listed for consideration of IA number 2 of 2022 on Thursday, 14th July.
Obliged.
29, please read that, Prabhu. Government certificate.
What about what happens to office objections? What is the PIS? Oh, this is yes.
And there are about 4 gates to the graveyard. Since past 150 years, this is being operated through the 4 gates. Annexure B is 36 minutes per month. Here, they are trying to open a new gate, and the access to that gate runs through a residential area with a predictor of this.
We page
38 medicine.
38.
But here, this is the residential area. A totally residential area. They are opening the gate at the far end. In the bottom photograph, you can see. They have demolished the compound wall which was existing. There was a stone compound wall which was existing.
What, they are opening a gate to graveyard?
Yes, putting a gate to graveyard. There are already 4 existing gates to the graveyard, 5 existing gates. Your Lordship will see next page, page 39, where the existing gate is there. This is gate number 1 to the graveyard. Page 39. This is the existing gate. You want to have this photo. Now, though this gate is existing, and there are a few other gates to this area, 41, page 41 will see. There is also a gate which is accessible through a field, a huge field. Though these existing gates are there, at page 41, they are trying to set up a gate in a road that runs.
They means who? They means who?
The persons who are in charge of the graveyard. So, what will happen is that they will have to bring dead bodies to residential areas. Though they have 4 access gates which are easily accessed. This will cause huge difficulty for the resident in that area. Third respondent, third and fourth respondent, second and third respondent. They are trying to erect the structure very fast. And if the gate is erected, they will start putting the bodies to the residential area, residential zones. It will cause a lot of difficulty. All these photos do not show that they are running through residential zones. It's a very narrow road. At that road, there is already 4 gates that are existing.
Carrying that body to respiration.
Obstructing that gate.
utilize it. So we will restrain them. We'll issue notice.
Yes.
Carry the to prevent to restrain them from carrying the dead body through residential area.
No, what will happen is that I will tell you. Let them for the time being, not let them because they are still erecting the structure. Earlier there was a compound.
Structure means gate, right?
No, earlier there was a compound wall, a stone compound wall. Now they are trying to erect the gate structure. Let them not erect the gate. Let there be an order directed to not to erect the gate. Let them come before your lordships and satisfy and do the undertaking.
So have you given any sort of
Yes,
representation
we have
before?
given to the BDM. Yes. We have given the representation. Page 23.
Vivek Reddy, learned senior counsel with Mr. Sridhar Prabhu. When will you comply with office of?
In 2 days time.
2 days. Oh, this is 3 days. Oh, Mr. Sridhar Prabhu undertakes, learned counsel undertakes to comply with office objections within 3 days. But on the question of admission and interim leave, learned senior counsel for issue notice, learned senior counsel for the petitioners submit that the that respondent number 3.
Yes.
Respondent number 3 is constructing a new gate to the graveyard. It is further submitted that 5 existing gates are already that 5 gates are already existing for ingress and egress to the graveyard. It is also urged that if the respondent number 3 is permitted to construct the 5th gate, the 6th gate. Oh yes, yes.
On B and C.
On it, 6th gate.
On B and C street.
What B and C?
The
All right, so it's constructed a new gate, the dead bodies may be carried through the residential area, which may cause great inconvenience to the residents of the locality. In view of purposes, then say issue notice. Issue notice to respondents in view of purposes submission. It is directed till next date of hearing. The respondent number 3 shall not construct a new gate to the graveyard. Please.
Okay.
Authority, Sri Vijay Kumar, Government Advocate.
Yes. 2 weeks time is granted to comply with office.
Sri Nalaye, number 31, Sri Ramesh Chandra, Government Advocate. Sri Ken Puttagowda, Sri B.T. Prasanna Kumar, Sri A.T.
Extension of time. What is it?
We have filed the IM not seeking extension of time to render the inquiry. Not this honorable court had by order in November 4/10/2021. This honorable court had directed the inquiry has to be conducted by local. But that order was communicated to us.
Not in how much time?
4 months. 4 months. 22 DVOs we have identified. 22 persons we have identified to whom we have to issue notice and call for response.
So, what do you seek and how much time do you seek?
4 months from the date of appointment of the present honorable local government, which is 15th June. 4 months from that date.
15 June 2022. Are the presence for the reasons assigned in IA 2 of 2022, time for completion of the inquiry as directed by this court-wide order dated 4/10/2021 is extended for a further period of 4 weeks. 4 months. IA 1 of 22 is disposed of.
32, Sri D. Vachan.
Let appear for the respondent.
What dismissed?
Non-compliance of the officer.
Order dated so and so is recalled. Number 252/22 is restored to file. And when that now writ appeal will come at some other time, then you take 2 weeks time. What is there? Who is in a hurry? We have restored writ appeal today.
Thereafter, it will come up again for complaint of office objection. You can again seek time. Right, no hurry. Yes.
For admission, number 33, Sri Ganga Annamaya, 14%, Srimati Esther Renuka.
Yes, madam. What is the special order? Yes, please.
The employer unpaid gratuity interest on the related gratuity. There are two orders for passed by one from the Supreme Court and another this bench.
This is 33.
One three.
Ask him to
Wait, ಸ್ವಲ್ಪ wait ಮಾಡಿ.
ಹೇಳಿ ಮೇಡಮ್. Yes, para 8.
See, the judgment, the short question that arises for consideration of this court in the appeal is whether the appellate corporation is able to pay interest at 10% per annum on the balance of gratuity payable to respondent. This question is fairly covered by the provision of the Gratuity Act and the view of the judgment in Dictionary case. This appeal does not survive or consideration. Accordingly, the appeal is dismissed. Under the above circumstances, the appeal is instituted for the interference of the Honorable Court in the interest of justice and peace. This is my prayer. After the decision of this court, the KSRTC is not challenged with this order and issued the endorsement that the Supreme Court has been passed an order. The order is not precedent to other cases. You are not approved to the Supreme Court and you are not eligible to obtain the interest. But the Honorable Appellate Court rightly passed the order when the prior order of this Honorable Court to pay the interest to fairly all employees, the Appellate Court rightly passed the order to limit it to their order only for the parties of the SLP. To eliminating the difficulties of the affecting this court order, the court rightly passes the order. I am not aware that the KSRTC paid the gratuity interest for all the employees and they given the wrong endorsement. That I pray for interference of this court.
Yes.
Accommodate to pay the interest. I have been age of 82, 83, and several diseases I have suffering. I am an eligible person for Article 14, where Bhagavati has been held in Rayappa case and also Maneka Gandhi versus Union of India. No discrimination is to be done in territory of India. Similarly, treated matters.
Yes.
These circumstances.
What is Maneka Gandhi, right? What is Maneka Gandhi's decision? Does it deal with discrimination? Or it was a case of impounding of passport of a person without notice?
What is Menka Gandhi? All right, fine. Okay. Yes. Okay. That's you are no. In brief, we have understood that you are entitled to payment of interest at the rate of 10% on the amount of gratuity. That's your case. Fine. Yes, madam.
My lord, I have produced, my lord, annexure R1 along with my objections.
6% is given. You want 10%.
My lord, the 6% is given and he is a party to the said writ petition. That has become final and he has not questioned. And without questioning, my lord, he wants 10%. Yes,
Madam Renuka, wait.
He wants to say something else.
Let him finish.
No, nothing. You argue your own case. What she's saying is already know that you are a party to the division bench decision. Division bench decisions.
Now allow the other side counsel to address. Ali VC nalli madam idare other side KSRTC ಅವರು ಅವ್ರು ಮಾತಾಡ್ತಿದ್ದಾರೆ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. Yes.
He wants to say anything further, he can say so. Whatever he wants to submit.
ಈಗ ನೀವು ಹೇಳೋದು ಮುಗಿತಾ ಅಂತ ಕೇಳಪ್ಪ ಅವ್ರಿಗೆ. ಆಯ್ತು, ನಿಂತ್ಕೊಳ್ಳಿ.
Yeah, all right, madam. Yes,
against the order passed by the division bench.
Yes. We understand. He is a party to division bench. He is not challenged.
Yes.
And order of Supreme Court is not a precedent.
Not a precedent. That's all.
Thank you. Sorry, we pass an order today.
34, the RG Collect, government advocate.
Yes.
My lord. The second round we are coming. For the first round, at page number 25, I have based all the last paragraph at page number 27. We therefore dispose of this petition by directing the respondents in the court to consider the request of the petitioner for refund of the entire amount in terms of the order dated April 5, 2011 within 3 weeks. That order of that date is produced at page number 36. The relevant portion is 36. Last paragraph. In the aforesaid view of the matter, we have passed a slightly different order, which can be made applicable to the petitioner as well. While accepting clear made by the applicant petitioner for modification clarification, we consider it just and appropriate to allow the respondents to refund to the petitioner proportionately to lease amount, keeping in mind the period of unexhausted lease result on account of the termination thereof, with effect from 31/3/2000 or on account of interim, direction, or other orders passed from time to time. In the present case, my lord, I was granted a quarry lease to extract sand valid for a period from 5/1/2010 to 4/1/2011. 1 year.
1 year.
1 year. With a condition that committee earlier termination thereof in view of introduction of new sand policy. As new sand policy never came within this period, it came in 21 July 2011. Now that may not be expected. But in the instant case, the other division bench passed an order stating that you cannot use mechanized boats for extracting sand in Krishna River, despite a condition in the public notice. But that condition was not incorporated in the lease. But however, the order passed by this honorable court restraining the petitioners not to employ mechanized boat continued till the expiry of the lease. In view of that restraint order, we never varied any quantity of sand. No tangible evidence, nothing came up, except issuing an order passed questions to the order passed by this honorable court, a copy of which is produced at the annexure A at page number 16 and translated copy at page number 21. Therein, the first order of the official respondents never take up that contention, but for the first time they take up this keeping order that despite restraint order from the High Court, petitioners were indulged in which is unfounded. There is no semblance of evidence, neither any documentary proof or any evidence by way of sworn affidavit or having permission in inquiry. Nothing is. Neither there is seizure of any properties or mechanisms, both or any equipment as is requirement. And Honorable Apex Court very recently passed an order, my lord.
Yes.
Last page, my lord. Paragraph number 13. You know, already referred to the demarcation report related to and so, and the report of the mining officer related to and so, on the basis of which no conclusion can be reached about the appellants indulging in illegal mining operation. The termination order and the appellant order are arbitrary and suffer from voice of unreasonableness. Relevant material has not been given to consideration before the termination order. There is no mention of DFM's report related to info, which considered the reports relied on by the director and absolve the appellant of indulging any illegal mining activity on the ground that no evidence was found against the appellant. There is no other material against the appellant in support of the allegation that the appellant was engaged in illegal mining in the area adjacent to the. In our view, the High Court committee
Permitted.
High Court committed an error in dismissing the writ petition without examining as to whether there was an iota of evidence to justify the term. We are aware that constitutional courts, in the exercise of their power of judicial review, would not examine sufficiency of evidence. In the same time, it is well settled that interference is warranted if it is found that the weight of the evidence was opposed to the conclusion ordered or there was no evidence at all, rendering the conclusion expressly erroneous or false. My observation is that there is no evidence found. Then, as my special mentioned, the official respondent cannot say that I was forbidding legal. In view of the order passed by my lords on 2 occasions, I am entitled for refund, proportionate refund of unspent this period.
So, till how much time you have carried out according to you?
Hardly till the order came to be passed by this honorable court on 20th April 2010. So from 5/1/2010.
5/1 till 20th April you did. Thereafter you are.
No, even in that period also, I have only made preparations to carry. But not removed because of Krishna River flow. Yes. River itself. In Maharashtra, that different situation is there in Karnataka. Different situation.
That's all. Yes, sir. So what is the material to show that?
Refund of the entire for a period from 5 to 2010. Yet in granted leave for a period of 1 year. It was expired on 4/1/2011. Yeah, sand policy came into effect from 29/1/2011.
20?
I beg before on this point. There is only a proposal, but in fact, sand policy was it came to be.
You will have a right of rejoinder, please. So, what sand policy?
Came into effect from 29/1/2011.
20th September.
29th January.
January
2011.
Yes.
As per auction rules, condition number 11.
So after expiry of the period of lease, that's what.
One of the conditions of the auction document is that he is not supposed to use mechanized boats. Document kindly say statement of objection annexure R1. Condition number 11 and 17 in page number 17.
Annexure R1.
R1.
Yes.
Okay.
R1E.
Condition number 11 in page number 17.
Yes.
Use of any boat, national and 70. And it would be valid for a period of 1 year from the date of that. On 3/1/2011, he has successfully completed this period. There is no dispute about it. On 3/1/2011, as per annexure R2, as per the direction of government, a letter was issued to the petitioner as per annexure R2, intimating him for continuation of this particular lease period. The extension will be granted provided if he pays the specified amount. If the lease period was over by 4/1/2011. Thereafter, as per annexure R3, the number 23. Petitioner makes a request to extend the lease. However, he sought time for payment of the statutory amount due. He did not make the payment. However, illegally he has continued to work. Therefore, we issued a notice as per annexure.
Mr. R4. Yes.
So, stopping the hand leave number, which was expired. So his order for extension, he has not made the payment. So his leave was expired on 4/1/2011.
2011 itself. And it is not entitled for any continuation and by the virtue of sand policy also. And it is fully covered by the judgment of this honorable court, which is produced by petitioner himself at election pay number 1. It is in the very same district, but the lease is also of the same period. It started from 5/1/2010 to 4/1/2011. There also the petitioner sought for refund of the entire amount for not allowing mechanized to go. They provide and the sanction to pay directly paid 43. And as the date of filing date for extraction of sand was granted in favor of particular analysis, conditions governing leave did not permit use of mechanized. Subsequently granted by communication. So and thereafter within 1 month set for is directly issued 24 preventing use of mechanized work for extraction of sand. Therefore, it is contained of the petitioner while they bid for foreign aid for extraction sand. You are aware of foreign activity was mechanized support and that whatever concession that was given to them pursuant to the communication dated 19/2010 is only a period of roughly 1 month, which in no way disturbs the mining activity of the petition. It is also stated that pursuant to the lease, the mining activity was carried on completely for a period of 1 year by both the petitioner, that is from 5/1/2010 to 10 till 4/1/2011. As that they are not entitled to seek refund of alleged loss said to have been suffered by them, entitling.
This is statement of objection, right? Or finding.
They are not in para 5. Counsel for the petitioner and going through the orders related on the counsel for the petitioner, it is clearly seen that they are made in this petitioner is invalid. As much as the petitioners have successfully completed the
Fine.
and in the grounds petitioner takes up grounds paying them. And
Who prevented him from quarrying? Nobody.
Nobody is prevented. He only requests for extension of leave.
Fine. Yes. My submission would be who prevented you from quarrying, right? So this order was passed. That was the condition. What was the order passed?
April.
What is the order passed?
Initially, it is very specifically mentioned at the particular portion. I mean, the point of time.
Yes. Which page? Page number 22. Yes.
I think one paragraph above the last.
Mechanized port, that was, yes.
As per reference from the 7 above, we have requested to refund the proportionate bid amount as per your list. Pursuant to the order dated so and so, passed by the honorable court. So in the last paragraph, as per reference 8 above, your proceedings cited in reference 7 have been examined in the light of Karnataka management. And the validity period of valid lease is for a period of 1 year, commencing from 5/1/2010 or earlier till introduction of new and policy. The same
condition the querying leave is granted and that you have agreed to bid by all orders, circulars and instructions to be issued by the government from time to time. You have signed the querying lease, moreover, you are querying lease.
Where is this order? Where is this order dated?
That order is not produced because it is kept in the speaking order that will be submitted to police department.
You have argued, Mr. We have heard for half an hour. End of it. We will get the order. Don't worry. But you should have filed.
I think you sorry, my lord.
You should have filed. We will get it. Don't worry. Which order? Order. Mr. Nataraj, you did get that order.
And in my
Order dated 20th April 2010, 24th April 2010. Which order dated 24th April 2010? This is 24th April. I mean, we don't know which is 20th April or 24th April. Page 22, type copy, it's 24th April. It's 20th April 2010. WP number 13355 of 2010. Fine.
in that instant order.
What instant order? Nobody will carry out any querying activity.
Even otherwise.
Wait. Let him complete. We have got it right now. It's a blanket order, right?
That order, the final order, I have produced in my PGI. It is page number 75. And it's
75. This is some other order. 3rd of February 2011. You told us 5th April. You told us 20th April 2010.
Interim, I think it is the same order 13355 2010. The final order. And that is interim order, which was referred to the speaking order.
Yeah, what is it? Please don't confuse. What is? No, got it, Mr. What is your case is on account of 20th April 2022?
That is interim.
Interim order.
Yes, that was an interim order.
Interim order passed on 2010 in WP 13355.
Yes.
You cannot carry out query operations and therefore you are entitled to refund. Simple, right? Sum and substance. Then you should have placed that order on record. First thing, that this is the order by virtue of which I have restrained.
In the final order, it is made clear, my lord.
I don't know what is. We will get this order, Mr. Nataraj. It's that order. Fine, that's it.
Yes, and moreover, another submission is that after the expiry of the lease period, extension of the period.
No. Why did you make a prayer for extension if you are able to carry out?
Friend has raised this, that's what I wanted to counter. I'm not concerned about that.
No, we are asking you that if you are unable to carry out any querying operation, why did you ask for an extension? You should have said, I am unable to carry out. Please, don't extend my query lease. I can't do it.
That is one of the petitioners should refer. But immediately he got vice counseling and said that no, he has not paid money. And I said, I'm not going to indulge in that. He has never been there. From the date when the restraint order was passed by the honorable court, he obliged them, he has not done any of the activity.
That's it. Anything else?
And initially, my lord, there was no prohibition for use of mechanized board. But on
You have told us that there was a complete prohibition of any querying activity in the state. That's why you could not work the query. And that order, we will get it. We will find out whether it's a complete prohibition or not. It can't be like this. Thank you. That's it. What does we get it now? Yes. The prohibition was only with regard to. Yes. All right. One minute. Just you will write, you will give it to him, I will write order. Huh? 14%. HR Renuka, Learned Council for Respondent. This intra-court appeal under Section 4 of the Karnataka Court Act 1961 has been filed against order dated 30th May 2017 passed by the learned single judge, by which the appellant has been held entitled to interest at the rate of 6% on the amount of gratuity. Paragraph. The facts giving rise to filing of this appeal briefly stated are that the petitioner, that the appellant is an employee of the Karnataka State Road Transport Corporation, within bracket herein after referred to as the corporation, was an employee. The appellant superannuated in the year 1997. Full stop. 1997. Full stop. It appears that the appellant made a claim before the division made a claim before the division made a claim with regard to payment of interest on the amount of gratuity. Full stop. The aforesaid claim was adjudicated by a division bench of this court. Wide judgment. In WA number 2059-2115/2013, in which it was held that the appellant is entitled to payment of interest at the rate of 6% on the amount of gratuity. Full stop. The aforesaid full stop. Admittedly, the appellant did not assail the aforesaid order passed by a division bench of this court, and the said order attained finality. Paragraph. It appears that some other employees filed SLP number 33440-33496/2010 SLPC number. The aforesaid the special petition was decided by the Supreme Court. The relevant extract of the order reads as well, right? Line below. Thus, from the aforesaid order passed by Honorable Supreme Court, it is evident that only the parties before the Supreme Court were held entitled to interest at the rate of 10% per annum. The paragraph. The appellant made a claim for grant of interest at the rate of 10% on the amount of gratuity. The aforesaid claim was rejected by an endorsement dated 4/3/2014. And the appellant was held entitled to interest at the rate of 6% on the amount of gratuity. The appellant challenged the said order in a rate petition, which has been discussed by learned single judge by an order dated 30th May 2017. In the aforesaid factual background, this appeal has been filed. Paragraph. Party person submitted that he is entitled to, he being a retired employee is entitled to interest at the rate of 10% on the amount of gratuity. On the other hand, learned counsel for respondent submitted that the order passed by the division bench of this court has attained finality, and the appellant is only entitled to interest at the rate of 6%. It is also pointed out that the amount of gratuity has already been paid to the appellant. Paragraph. We have considered the submissions. We have considered the rival submissions and have perused the record. In the admittedly in the appeal filed by the appellant, he was held entitled to payment of interest on the amount of gratuity at the rate of 6%. 6%. Full stop. The appellant had not challenged the aforesaid order in the special leave petition. The order passed by the division bench has attained finality and binds the parties. Full stop. Binds the parties including the appellant. Full stop. So far as the reliance placed by the appellant on the decision on the decision in SLPC number 333 440-33496 part 2010 is concerned, comma, suffice it to say that in the aforesaid order, the Supreme Court itself has held that it shall not be treated as precedent in any other case. Full stop. Therefore, the decision of the Supreme Court in the aforesaid SLP is of no assistance to the applicant. The amount of gratuity as the interest, admittedly, the interest at the rate of 6% per annum on the amount of gratuity has already been paid to the applicant. Full stop. Paragraph, for the aforementioned reasons, we do not find any ground to interfere with the view taken by learned single judge, and the result of the case and is hereby dismissed. Got it? Getting that. WA number 9 WP number 9921 bar 2017. This rate petition, comma, in this rate petition, comma, the petitioner inter alia seeks the writ of certiorari to Deputy Director Department of Mines and Geology. Refund the entire or proportionate bid amount as well as the amount of security deposit to the petitioners on the ground that the petitioner was prevented from carrying out the quarrying operations as per the agreement of quarrying lease for a period from 1 year, that is from 5/1/2010 till 4/1/2011. On account of interim order dated 24th of April 2010, passed in WP number 13355 part 2010. Facts giving rise to filing of this petition briefly stated are: that the petition was granted and that the petitioners were highest bidder in the auction held for sand mining for a period of 1 year with effect from 5/10/2010 to 4th of January 2011. On as inverted commas, as is where is basis, full stop. The as is where is basis, full stop. It is the case of the petitioners that on account of an interim order dated whatever you have written just now, so and so passed in the WP number so and so, the petitioner could not carry out any petitioners could not carry out any quarrying operations for a period from 20th April 2010 till 4th of January 2011. Full stop. 4th of January. Before that, you write the lease deed was executed in favor. When was the lease deed executed, Mr.? Was granted so and so highest bidder, no? Thereafter, you write one sentence, highest bidder. Thereafter, the query lease was executed in favor of the petitioner on. Sir.
Yes, ma'am.
Was it, you say where thereafter query lease was executed in favor of the petitioner, under which the petitioner was permitted, petitioners were permitted to carry out the quarrying operations for a period from 5/1/2010 till 4th of January 2011, right? Then it is the case of the petitioner, right? case of the petitioners that on account of an interim order dated so and so passed in WP number so and so, they could not carry out the querying operation. Full stop. They could not carry out the querying operation. So thereafter, they had submitted a representation which has been rejected.
No, honorable court was.
Just a minute.
Direction.
Just
After the expiry of the.
no. Which is that 4th December 2016 is the order, right? Which 4th December 2016 is the order. 14th December.
Yes.
We will get the facts here. The petitioners were auction purchasers. You written auction purchasers. The highest bidder in an auction held on 5/1/2021 in respect to numbers as is various basis. As is various basis. Whatever. The query list was executed, then is a case that on account of so and so. Right? Then after expiry of the period of paragraph, after expiry of the period of lease, the petitioner submitted. So by a communication dated expiry of the period of lease executed in favor of the petitioners, the petitioner by a communication dated 12th of January 2011, Mr. Yes. No, not R1. Option was given to him, right? That he can continue, which is that? 3rd of January 2011, not 12th. 3rd of January 2011, the petitioners were apprised that the query lease period can be executed, can be extended in their favor, provided they pay the bid amount. Pay the bid amount as well as the requisite charges in this regard. The petitioner thereupon by a communication dated 12/11/2011 expressed their willingness to for extension of the period of lease and sought time for payment of the requisite amount. However, the requisite amount was not paid by the petitioners thereupon by a notice dated 23/2/2012. 23/2/2011, the petitioners were informed that their application seeking extension of the period of lease for 3 months has been kept in abeyance, right? Full stop. The petitioners, however, made a claim seeking refund of the amount of whatever you have written in the beginning. Made an application seeking refund of the bid amount as well as the amount of security deposit, which was rejected by the Deputy Director, Mines and Geology Department by an order dated 14/12/2016. Full stop. In the aforesaid factual background, this writ petition has been filed. Paragraph. Learned counsel for the petitioner submitted that in view of the order dated 20th April 2010 passed by division bench of this court in WP number 13355/2010, the petitioners could not carry out the query operations with effect from 20th April 2010 till 4th of January 2011, and therefore are entitled to refund of the amount of they are entitled to refund of the bid amount, proportionate bid amount as well as security deposit. Full stop. It is further submitted that there is no evidence on record to show that to indicate that the petitioners have engaged in querying operations. Full stop. Querying operations. Full stop. It is therefore full stop. In support of opposite submission, reliance has been placed on reliance has been placed on the decision of Supreme Court. Supreme Court in Haryana Mining Company versus State of Haryana and others, 2022 SCC on line SC 577. On the other hand, learned additional government advocate has, on the other hand, learned additional government advocate has invited the attention of this court to the terms and conditions contained in the query list executed in the favor of terms and conditions, namely clause number 11 and 17 of the terms and query list executed in favor of the petitioner. It is further submitted. That the new new sand policy came into force with effect from 29 January 2011. It is sand policy that what came into force. All right. Oh, fine. Learned additional government advocate, while inviting the attention of this court to condition number 11 and 17 of the ordinary sand auction rules and regulation, has invited the attention of this court. That's all. It is also submitted that the new sand policy came into force with effect from 29 January 2011, and it is also submitted that that this court did not direct prohibition of the quarrying activities in the state of Karnataka, but only directed that the what shall not be used?
Mechanized boats.
That the mechanized, but only prevented the use of mechanized boats in the quarrying operation. It is further submitted. All right. It is further submitted that the petitioner, after expiry of the period of lease petitioners, after expiry of the period of lease themselves made a request on 20th/12/2011 to extend the lease period and sought time to make payment of the amount due for extension of query lease. Good one. Submitted. It is also submitted that in similar circumstances, a division bench of, that in case of a similarly situated person, in case of similarly situated person like that of the petitioner, a division bench of this court has dismissed a writ petition. Namely WP number. WP number, just a minute. WP number 19064-19065/2012, to which reference itself has been made by the petitioners.
That judgment is issuable. That's why I have produced
that. Is a submission, Mr. We have heard you. I mean, now we have heard you, right? You told that's all. Thereafter, we should have that liberty to pass whatever judgment. Don't interrupt. We are recording his submission. It may be, according to you, it may be wholly irrelevant. And the deputy director should be imposed fine, according to you. And see, Mr. Don't make a statement like this. We have got the order. There was no absolute prohibition on my querying. It's unfortunate. Yes. Paragraph. We have considered the submission.
Final order
fine.
Final order is that.
No, it's your. All right, we are not entering into your argument, any sort of an argument. That's why you have understood why we don't dictate the orders in presence. This is what happens. You start arguing again. That's why we wait till you go out. This is what happens because you can't practice. Right? You have argued. We have heard you, right? This is what you have argued. Everything we have noted down here. Don't interrupt, please. Only one thing. When did he first made an application for refund of the amount? Seeking refund. When did he first apply? That's all. We have considered the submission made on both sides and have perused the record. The order dated 22nd April 2010, passed in WP number 13355/2010, reads as under quote. Reads as under, right? Quote. Full stop. Thus, from perusal of the aforesaid order, comma, it is evident that uh, that that the condition which permits the lessees to use one mechanized boat for quarrying was stated by a division bench of this court. Thus, it is evident that there was no absolute ban on the mining operation. Full stop. The contention of learned counsel for the petitioners that mining activities were banned completely is incorrect, and therefore is incorrect and does not deserve acceptance. Full stop. Paragraph does not deserve acceptance. Full stop. It is also pertinent to mention that the query lease was granted to the petitioners for a period of 1 year from 5/1/2010 to 4/1/2011. On the on the expiry of the period of query lease, the petitioners themselves by a communication dated 12/11/2011 requested the deputy director to extend the query lease for the further period of 3 months and sought time to make payment. Full stop. Full stop. In ordinary course of conduct, the petitioners themselves at the first instance would have approached the authority by stating that they have been unable to carry out if the ordinary course of conduct, if the petitioners would not have been able to carry out quarrying operations, they would have stated so. They would have brought this fact to the knowledge of the authorities at the first instance. Full stop. On the other hand, instead of bringing the said fact, on the other hand, the petitioners themselves have sought renewal of the query lease. Full stop. The query lease. Full stop. Thereafter, they have been sent. Thereafter, the petitioners did not pay the requisite amount for renewal of the query lease. Thereupon, a notice was issued to the petitioners. Full stop. The contention of the petitioners that on account of interim order dated 22/4/2010, passed in WP number 13355/2010, they were unable to carry out the quarrying operations is wholly misconceived. For the aforementioned reasons, we do not find any infirmity in the order dated 14th of December 2012, passed by the Deputy Director. In the result, the petition fails and is hereby. Okay. Yes, sir.
Next, in this matter, I pray for do these times file additional statement of objection.
All right. Learned additional government advocate for respondents praise for is granted 2 weeks time to file him to enable him to file additional statement of objection. Before that, you write, mark their presence, learned counsel for the petitioner seeks leave of this court to withdraw prayers made in para 16A and B.
Yes, sir.
16A and B of the writ petition. Let is permitted to amend the writ petition. Learned additional government advocate, praise for
A and B.
A and B.
Then I have already filed statement on
A and B, let necessary amendment be carried out within 1 week. 1 week less thereafter.
36, Sumoto, K. P.M. Chowdhury, P.M. Nalgundar, government advocate, Narasimhan, Yogesh Nayak, N. Suresh.
Yes. No. So what have you done? 83 notices were issued. What happened thereafter? Huh?
What is the panchayat law? State government was required to submit other aspects.
Huh.
I need to get instruction. This time I will file the status report in respect of action taken.
Yeah, after 4 years instruction, what is 4 years is pending, right? Why are you appearing? You have been held disentitled, right? You want cost to be a further cost to be imposed on you. Then you have been held disentitled, right? Huh? Of course. Please, it's a suo motu. That's what we were wondering. That in a suo motu petition, how you are appearing?
Yes, my name is. My name is.
Fine. Office is directed to delete his name. Delete name of Mr. So and so as counsel for petitioner. Fine, relax. What is it? What this is 2019 the order was passed, right? What not if they are not getting intimation through you, we have better means, faster means of communication. What action? This public line below. This public interest litigation has been filed. This writ petition has been treated as suo motu petition with regard to the encroachments within the limits of respondent number 4 Gram Panchayat. The who has filed? You are respond number 2. Who is respond number 2? Who has filed that? It is 3 notices. Respondent number 4. Who are you? Gram Panchayat. Respond number 4 has filed a reply stating that 83. You said 83 notices. Oh. Where? 26-2. 26-2. 21. Yes. Learned additional the learned counsel for respond number 2. No, in the reply it has been pointed out. In the reply it has been pointed out that respondent number 2. Respond number 2. 4. Respond number 4, not 2. Respondent number 4. Entire development officer has issued as many as 255 notices to the owners of these structures on the ground that the same have been illegally constructed. Full stop. There are full stop. This court on a bench of this court by an order dated 26/2/2020 had directed the state government to provide adequate staff to the Gram Panchayat to take the action for demolition of illegal constructions. The state government was further directed to to take an appropriate decision in this regard and to place the same before this court on 27th March 2022. However, however, the additional government advocate prays for adjournment. By way of indulgence, let this petition be listed after 2 weeks. 2 weeks. The state government shall take a decision as indicated in the order dated 26/2/2020 to enable the respondent number 4 to proceed further with the matter.
But 37, in the Prakashya, government advocate, Gujarat Justice. Yeah, that's it.
Yes.
Number 2 is lecture D.
Lecture
Lecture D.
D.
One of the last pages on the report we made it. Wherein a representation was given to the government that sites which were allotted for CA sites and any public sites and park sites that converted illegally into residential sites and sold by the society. Then objections were raised, I gave a representation. After my representation and the order in restriction, the government held an inquiry. A committee was appointed and order was passed by the government at election, wherein actions were directed to be initiated against officers who were found guilty of this illegality which was committed. FIR also, I'm told, is registered now. And there was an order also to take possession of the vacant sites which were available.
Where is that?
That is annexure A, my lords. In page number 15, the typed copies, that is translated copies. Page number.
It begins from 16.
23.
Yes.
Point number 2. The houses are constructed in the site formed by reducing the park for taking the set areas into possession of. Also, there is likely that the family is residing by constructing the building will be put to hardship. Considering all the strategies, providing alternative ways proper. Hence, by retaining the sites, the houses constructed as it is, totally the reduced park and public public space reduced in the plan. In view of providing in the city level. What the conclusion comment of such is by virtue of directing the already constructed houses to be demolished, it will incur more expenditure to the state. The lenient view was taken so far as houses which were constructed, where the illegal sites houses were constructed, but what houses were not constructed, they were directed to be taken possession of. So this initially, this honorable court directed the government to explain as to why this discrimination is done. So far as vacant sites and sites which under what policy or under what provision of law.
So you are kind to respond.
That was the explanation which was sought for. So my explanation submission to your office space. So it is not their case that I am personally interested in this, it is a public reason. So the discrimination what is made is the vacant sites are taken possession of in furtherance of my complaint. And so far as house constructed by some rich people and members of the society, which now has become redundant, and it is already administrator is appointed in view of all the illegalities found. Government has appointed an administrator. The president and other vice president and office bearers of the society's houses are still retained. That is the only part which I am challenging before this on. I am not agreeing with the other part. What my career.
Yes. What do you think, Mr. He said not taken.
Now buildings have come up. And there's no
I'll let him, we will hear. Hey, Mr. What is it? There are several orders, probably. No. Please see 5/11/2019. State government shall make a statement regarding source of power exercised by the government for issuing the impugned order. You have done that? We don't know. It says which provision? Source of power. Well, power means what under? That's what is the question. Which provision? One. You what? Yes, not it. Fine. We have gone through your statement of objections. Let him be ready. There is an order passed by this court. So they have to at least, we have to see. So how much time, Mr. Learned additional government advocate states that prays for adjournment to enable him to go through to prepare the case and argue the same. List in the next week, at least after 1 week. Ready, right?
Yes, Sharma, government educate.
Why? Not ready. Oh. Which he also prays for time, right? Yes, but you also pray for adjournment. Learned counsel for respondents. Petition council jointly pray for adjournment list after 2 weeks.
Ramesh Naik, party in person.
I appear for the High Court administration.
Yes. The
Petitioner has already alerted the ministry and this one about the need to transfer the relocate the building. Now his job is done. This matter is disposed of. Building committee is already seized of the matter. This can be internally sorted out. Where is the need for a petitioner to bring this petition? Then
you are appearing for whom?
And for the association.
What association?
Education association.
Whoa. We thought that you will make this thing submission, otherwise that it should be kept pending. Oh, you are helping Mr. Patil. What happens to Mr. This building old this thing election?
Can be sorted out by the building committee, that internally the Honorable High Court, Bar Council, and the concerned stakeholders can decide. Why should the third party not instigate this? And
No, it has been entertained. What I mean, let the what like yes, Mr. Patil, what do you say? No, but there are yes, Mr. Nagaran, there are no offices in the basement, right?
Lord, as of today, my lord, I am instructed to say that there are 3 offices, branches are still working in the basement. Now, my lord, yes, what happened was, my lord, that at the earlier stages of this case, the government, my lord, was asked whether they would give some additional accommodation. They gave some additional accommodation in another building where some sections have moved. Thereafter, my lord, we submitted that still more additional accommodation is needed. At that stage, my lord, the learned government advocate submitted that the chief secretary will have a discussion with the High Court administration and try to find some other accommodation. And that has not happened. Meanwhile, my lord, the Advocates Association also got implicated in this case. The main prayer in the writ petition, my lord, is that all basements cannot be used for humans beings to sit and work under the regulations. So they all have to be moved. So it is ultimately for the government now to make a submission and give alternate accommodation.
Taken by the Honorable Court internally, why not? It should be in a public case. That would have been of communication as respondent.
No, what happens to this old
building committee is there, not committee.
What you had on the last date of hearing, right? 16/11/2021. this court had observed that you should hand over this, or you should consider handing over building of old election commission and KGID. What happened? No, it says that's what nothing to do means what you have to come up with your stand on this. We request the state government to consider handing over. What is your stand on this? See, I mean, this court has also said that we hope that state government will come out with a positive response. Northern government advocate general to use good offices. Find out what is this. Yes, Mr. Nagaran, which offices are working in the which branches are working?
Lord, I don't have the exact details, but there are 3 branches still working, Lord.
But most of the offices have been shifted, right?
Yeah, most of them have shifted, but there are still, Lord, the thing is,
where it has been shifted, which place?
They gave us, Lord, another building. In that building, Lord, 1 floor was given to us, and in that, after shifting, Lord, in the technical education department, there was a building. They gave us some portion of it, and some of our staff have moved
which
there.
Building? Where have
called the technical education department building, Lord.
Technical education department building. Yes.
Yes.
Part of the building you have given. Drugs control department. Please put your response. What all you have taken? After 16th November. So please find out what is. I mean, we have this thing. This court had requested.
Lord, one more submission, Lord.
Officers and yes, please.
Lord, at the earlier hearings, one of the issues that came up, Lord, was that the Bar Council, Lord, has been given some accommodation. It is occupying one portion of it. So the Honorable Court, Lord, wanted to know if the High Court building which is given to High Court is given to Bar Council, they can make some alternate arrangement. And that building, if it is provided, it will be sufficient. The Bar Council, my lord, had some objection to that naturally, my lord, because they are now occupying some portion. So the Honorable Court, my lord, then felt that all these persons must sit together and government must find a solution. If they don't want to disturb the Bar Council from there, then...
That's what we are asking, Mr. Patil.
Please, ma'am.
Seek instructions, get back to us. No, we are not. This is public interest litigation. We can entertain it so moto. It's for the High Court. I mean, what? You should say that it should be dropped. Why? No, you said that it should be closed. Why it should be closed? No. It's on, so it will be on. What is there? Why you should make a prayer? It should be closed. Don't. At the most. That's why para 6 of the order passed by what last we have this thing of the division bench has requested they have to come up. I mean, it's not a question of issuing direction and adjudicating. We cannot forcibly take possession of any, but we hope and expect that government would come up with some solution, right? It's not that we are passing any order today. It's not an adversarial litigation. Nothing is happening to you. We are not doing anything to Advocates Association. What is it? You want that it should be closed? Nothing. Nothing. Don't say. We are all interested in finding out a solution to this. There is a problem, right? So we have. This court has requested Learned Advocate General to use his good offices to overcome the problem of space crunch. So let's see what they may come up. The negotiations may take place. It's not we are not doing anything against you, right?
Actually, the Advocates Association, my lord, must be interested in pursuing this case.
That's what we felt surprised that they are saying it should be closed.
Yeah. The entire basement, my lord, now chaotic car parking facility that is there, my lord. Today, if we come to High Court in the morning, it takes about 45 minutes to come out of the court to go to the main road. That is a chaotic.
Okay, but you know, I mean, with your experience, you know that this is a perpetual problem all over the country, like everywhere.
That's true.
It's
But
like that.
Some places, my lord, concerted efforts has been made, my lord, to resolve. For example, in Delhi, my lord, there's a big underground parking facility that has been created in the Delhi High Court. So there is no parking issue there at all. Here, they don't want to even regulate the parking, and the basement, my lord, is not made available for parking. There's still staff there.
We are dealing with this issue on the administrative side. We are dealing.
Grateful.
He knows about it. Yes. Market presence.
Your lordships are seized of the matter. We have complete confidence in the resolution on the administrative side.
Should we record that you are making a prayer like this and we reject it? Should we say so? We don't want to place it on record. Let it be there. Nothing is being done. I mean, I am surprised that it should come from. We are surprised that a request should come from the Advocates Association that it should be closed. Why?
The matter is being handled on the administrative side. All stakeholders are this juncture, the instance of this petition. Who has no interest in the matter? Why should
no, we are not dependent. See, Mr. You know the law. What is it? What has Supreme Court said in Sheila Bakse? You know it. Way back in 1988. So, and nobody is appearing. We are still entertaining. So it's a virtually sort of suo moto thing. Even if we want to, we can't dismiss for default. We cannot permit it withdrawal. We will have to adjudicate it. We are asking them to come up with a response to this problem. So let it be placed on record. Market presence. Everybody's. You are in additional government advocate. We grant you how much time? 3 weeks, 4 weeks? 4 weeks time. Learned is granted 4 weeks time to enable him to come up with a suggestion in the light of order. Enable him to come up with a solution in order to enable him to state the solution with regard to problem of space crunch faced by the High Court. List after 4 weeks.
Committee appointed in 2014. But before the members decided, we had appointed. In fact, the rules were amended in the year 2015. The effect of those rules have been consulted in the and they have been granting them time out at some. I have based on record what specific made 2020 order by which they have been given time out at some. He himself admits what page 96 that he has been given 3 promotions. In this case, is the 4th promotion is not given, and for that he says you amend the schedule.
Yes. What do you say?
The appellant Manat was appointed as an unskilled labor on contract basis in the year 1985. Thereafter, on 1/7/1988, his services were regularized. Regularized as assistant operator. As on the date of regularization, there were no cadre and recruitment rules by an executive order was regularized. Thereafter, the post of assistant operator as the appellant was regularized. Became redundant. And on 1/7/1993, and on 1/7/1993, the post of assistant operator is redesignated as mate assistant. Even as on this date, there were no cadre recruitment rules. The cadre recruitment rules with regard to the respondent company for the first time came into effect on 1/1/1994. Thereafter,
yes.
Your Lordship may kindly see the circular minutes.
Yes.
At page 90 minutes is the typed copy, and the original circular minutes can be found at page 88. But this circular minutes is dated 17 October 1995. Minutes from the bottom minutes 69. But in addition to these posts, it is further under consideration to create the post of sales assistant in the proposed marketing network in the hierarchy of marketing junior sales assistant, that is FDA, senior sales assistant FDA, assistant sales officer, assistant manager, etc. will be promotional avenues. This minutes is dated 17th October 1995. That minutes is subsequent to the cadre and recruitment rules coming into force. Under the cadre recruitment rules, 1/1/1994, which came into effect, there was no promotional avenue with regard to sales assistant. That was got to be remedied under this circular, and the promotional avenue that were contemplated, that is also mentioned. Now, what is being contained in as promotion? Prior to coming into force of the cadre and recruitment rules, is no promotion at all. It is merely an upgradation. If the appellant who is regular as an assistant operator is upgraded to a post of meet assistant, that is no promotion, because promotion mandates that he is promoted from a junior cadre to that of a higher post. In the absence of any cadre and recruitment rules, if the post can only be upgraded, and that cannot be from the promotion. Now, assuming that with the upgrade, additional pay also going to be granted, even then that would not suffice the requirement of promotion, because no cadre and recruitment rules were not in existence. So the upgradation on 1/7/1993 is no promotion at all. Now, the maid assistant who are working, the employees who are working in the respondent company at maid assistant, the post became redundant. The company came to the conclusion that the said post needs to be abolished. The employees who are working as maid assistant were given two options. One is to take up a competency exam and to get further promotions, subject to then clearing those competency exam. Now, maid assistant who did not intend to take up that competency exam, they were given the options of joining the cadre as sales assistant. Now, the appellant before Lordship has not taken up that examination. Now, he may not join the cadre of sales assistant. Now, under the present rules, which is placed before Lordship, the cadre recruitment rules, if the Lordship were to see internal page 41. It is not numbered. However, there are numbers. Now, from the court of maid assistant, there are other promotions as mind maid and senior maid. This is in the production maid. Now, if your Lordship were to take page 64 minutes, under the marketing minutes, at serial number 7, sales assistant. Yes. Now, this post which came from the sales assistant who took the option the mate assistant who opted to be sales assistant. Now, if you are logical to see the remarks, the cadre of sales assistants is proposed for abolition. At present, 38 incumbents are working in the cadre. The posts shall stand abolished as and when the incumbents vacate the post. In view of this, they shall be granted running scale so long as they are in service. Now, under the present rules, under the present cadre and recruitment rules, under the circular what was promised is the circular which are referred to of the year 1995 where the respondent company had contemplated promotional avenues to the cadre of sales assistant. Now, under the that circular now the employees who did not choose to take up the competency examination came to the cadre of sales assistant. Now, in the year 2014, under the said cadre and recruitment rules, if promotional avenues are denied, then they stagnate as sales assistant till they superannuate. Now, what is now the earlier promotions? What is being contained as promotions that have already been granted to the appellant are no promotions at all. They are merely upgradation of post with an enhanced scale. Now, that consideration had come up before the full bench of the Kerala High Court where they have specifically said that mere upgradation of the post with enhanced pay would not amount to promotion. This case, the Kerala High Court was considering the aspect of upgradation of a particular post and that of promotion. Some posts in cadre upgraded. Senior officials in the cadre would automatically get higher scale of pay. It is not a case of promotion because the officials continue to hold the same post. Now, on the cadre recruitment rules, the company which has formulated the promotion is also defined. Now, going by that, there is no promotion.
So, what is the relief claimed in the that to create post and to promote? Yes, that was the relief claim.
Exactly, similar request was made. Similar request was made. In the case of State of Tripura and others versus KK Roy the judgment had placed it on record in the early along with Dr. Oz. In continuation of Dr. Oz similar representation was made. The writ of mandamus was sought as against the respondent therein.
What is citation reported?
Yes, there's the citation minutes of mistake.
2004 9 CC 65. 2004 2004, 965, then the Supreme Court said, you get either promotional opportunities or time-bound advancement. With respect to stated, they are not to quote.
Which para?
Paragraph 6.
Para 6.
It is not disputed that the other states in union have regard to recommendations granted time-bound advancement. It may already granted.
My respectful submission with regard to time-bound advancement.
No, it's not a promotion, right?
Time-bound advancement would arise. In where there are no promotional avenues under a particular cadre. If there are no cadre and recruitment rules at all, as in the date of that particular scheme being floated, then under those circumstances, it would not amount to time-bound promotions. It is merely upgradation of the post with enhanced pay. Now, under the cadre and recruitment, now the present rules is of the year 2014. Either the rules which preceded the 2014 rules is of the year 1994. Either under those particular cadre and recruitment rules or under the 2014 rules, the cadre of sales assistant does not have any promotional avenue. Subsequent to these rules coming into effect, if a scheme was formulated, recognizing the fact that certain cadre of employees did not have any promotional avenue, then that would constitute time-bound promotion, not otherwise.
Same. Yes. That's it. Anything else? Yes. Yes, please. From 31/7/2008, page 58. Second is request for amendment of the cadre. The title copy is page 59. Not clearly because he is having a higher qualification, he should get promoted. That one is it. That was challenged by him. It is petition 26845 of 2010. Annex K page 64 is the difference. Then paragraph 2. Yes. Thereafter, the petitioner came to be promoted as a major assistant to the President President is namely he is postgraduate diploma in marketing and he has not been promoted to a higher post. The entire case was that I have made got a diploma, therefore you promoted. Therefore, it is finding. It is not in dispute that the petitioner is brought by cadre both the manager are speaking by effective amount of employees while the pay scale of 17,000, 1,720 less 50,000. And from among employees on right pay scale of 15, 20 and 29,900. Is these scales lower than the pay scale we cannot manage our as to the extent to promotion to the rank of the manager C and full manager C and from rank of office superintendent to assistant manager C is based on seniority from merit basis. The petitioner is not working as a manager or second respondent was weightage weightage should be time and same cannot as one. The only difference that he made was that he has to be promoted. Then on the second installment of litigation, where he says when he says you amend the cadre. These conditions are available to him when the earlier petition of 2015. Issue started with operated. He cannot come and install this. Then now he was telling that there was no promotion given to him. Annexure M page 90. It gave two options. See right? Either you pass the competency examination and go to higher cadre by promotion.
Of those who do not want to pass at all, they don't want to take the trouble of passing the competency examination, we will be creating a post of self-assistance. That we created. Nobody prevented him from taking the competency examination and moving higher in the med-assistant channel. Then nobody said, no promotion is there. And we take 93 months. Sit on the presentation. He admits that he has given 3 promotions. With reference to the above, I would like to bring to the kind notice the joint agreement of 1985 as an unskilled worker, and thereafter was promoted as assistant operator, gate assistant, and sales assistant on 1.87, 1793, and 1.4. 3 promotions he has got. Thereafter, the board decided for operational reasons that sales assistant post they have to abolish. This is what is said in the page 64 of the data recruitment. Direction to know what has happened. We have placed 2015 rules. Then on to page 64.
This is these are page 64. 64.
Page 64.
Yes.
Sales assistant, 38 posts. The cadre of sales assistant is proposed for abolishment. At present, 38 incumbents are working in the cadre. The post will stand abolished as in the incumbents. In view of this, they should be granted winning scale as long as they are in service. After 3 promotions, I am granting him time-bound advancement as a running scale. Every year he is getting advancement. He cannot again have any because after all, I did not prevent him from writing. Competency test, you pass the exam. He doesn't pass that. He chooses the easier, management training for the self-assistant. I didn't go. There was no assurance in self-assistant that we will create up to general manager.
Yes.
That's all I said.
With regard to constructive respicator, page 10 of my repetition notes have explained how the present repetition notes, the order which is included in the present appeal, is different from the earlier round of litigation. Now, if the petitioner were to make a representation, and if the observation of post which he was endowed with, if the petitioner who is not so educated, if he were to say that that is promotion, now placing reliance on that it cannot be said that he is already promoted. Now, irrespective of that promotion, what the company has done will have to be independently examined. That is one solution. Now, constructive respicator, that the limit in the order of reputation has referred to the earlier round of litigation, and the petition is not dismissed on the grounds of maintainability. Considering the merits of the writ petition, the order is being passed.
So, thank you. We'll pass it. Oh. Who is for the petitioner? Yes. So, when do you want? Thursday? All right. 59 mark the presence. Learned Senior Counsel for respond number 4, who has entered appearance on KVA, praised for a short accommodation list on Thursday, 14 July.
Serial number 51, my lord. Petitioner, my lord. Pray for timing next week, my lord.
Oh, nothing.
I am for petitioner. Serial number 51.
Yes. So you are not available. Like senior counsel, you are also not available, right?
Yes.
Huh? Yes. Oh. What 51?
51, my lord. 51.
Who is the other side? We will call it in the afternoon, right? Kivator, he is praying for adjournment. Any objection? No objection, right? 51.
Next
How
week,
can you oppose prayer for adjournment, right? Not possible. Huh? So how much time do you want? Yes. No, not objection. This is writ appeal. No, we are asking him. Yes. When he wants, how much time?
When do you want, sir? Next week, my lord. Next week, any date.
After 1 week. Learned 51, mark the presence. Learned counsel has entered appearance on KVA. Learned counsel for the applicant place for adjournment list after 1 week. 47. Yes. What? 47. All right. Mr. Ben. 47. Learned counsel for the petitioner. Praise for is granted 2 weeks time to enable him to file rejoinder.
Not repeat. ಯಾವುದು ಬರ್ರಿ
ಸರ್ ಹೋಗಿ ಪರವಾಗಿಲ್ಲ ಅಲ್ಲಿ ಹೇಳಿ ವಿಶ್ ಮಾಡಕ್ ಬಂದಿದ್ದೀನಿ ಅಂತ ಒಳಗಡೆ PS ಲಾ ಕ್ಲರ್ಕ್ ಇರ್ತಾರೆ ಹೇಳ್ತಾರೆ ಒಂದು 15 ಮಿನಿಟ್ಸ್ ಬಿಟ್ಟು ಹೋಗಿ ಸರ್ ಒಂದು 15 ಮಿನಿಟ್ಸ್ ಬಿಟ್ಟು ಹೋಗಿ ಸದಾ ಸಾಹೇಬ್ರು ಸ್ವಲ್ಪ ಮಾಡಿರ್ತಾರೆ ಜಾಸ್ತಿ ಹೊತ್ತು ಒಂದು 15 ಮಿನಿಟ್ಸ್ ಬಿಟ್ಟು ಹೋಗಿ ಕೂತ್ಕೊಳ್ಳಿ ಸರ್ ಕೂತ್ಕೊಳ್ಳಿ
My lord, in serial number 41, my lord, I beg to appear for the appellant's counsel. This is a writ appeal filed by my lord KIADB against the order of the my lord learned single judge, wherein the general award passed by the special land acquisition officer has been passed with a direction to pay my lord the consent rate of my lord compensation or agreement rate of compensation with interest my lord as contemplated on section 34 of the Land Acquisition Act. My lords, the
All right. Yes, we'll issue notice. You are appearing? All right. You accept notice? Notice on behalf of which respondent, Mr.
Only one respondent.
Respondent is accepted by the senior counsel. Office is directed. List reflect his name list. Good. All right. That's all.
I am sorry, my lord, if it is serial number 41 or not.
41 only.
Yes.
41 only.
Yes, please. I have sought for an interim order.
Let him. He has accepted notice.
Yes.
And we will consider on the next date your prayer for a stay. Yes.
42, the Venugopal CN.
Yes. Yes. Who's here? Who has to argue? Have you filed synopsis? Okay. Okay. Ask.
Number 43, the Krishnamurthy, government advocate, Srimati Veena TN, Malika Ishwar Bhatt.
Yes. 43. Yes. A state you have filed, Mr. Mahendra. Which memo? No, that's all right. That was in pursuance of the interview. What's the statement of objection you filed? We want to know. Yes, sir.
The district party has filed. In this case, they would like to file rejoinder on this before it is filed. The state cannot, because there is a party document.
And what is this public interest litigation about?
Lord, this is about a quarry, illegal quarry operations is being held.
No, but you want. All right.
Redstone quarry.
Who are you? Public spirited individual, right? You have not submitted any application for grant of lease, which has been rejected.
You also filed annexing.
You have not filed any application to the government, right? Seeking the lease. Sure, sure. Many cases we have found. So, Mr. Fai, we'll like to see this thing. No. Either you make a statement you are relying on Mahazar only, then we go ahead, or you file, we are granting you opportunity. Please do it. Learned mark the presence, learned additional government advocate for respondents 1 to 3. How much time? 2 weeks. Grace fund is granted 2 weeks time to enable him to file objections. Thereafter, you may file rejoinder after going through what state says, right? Whatever.
It's only one line statement saying that at present there is no quarry. Only one line.
The party code, Summa to KA, government educate, MR Hintena.
Yes. 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 All right. What is the scheme? When is it? 3rd February. How many members? Right? Annexure R1.
Licensing mechanism is created. Just make an application to the justice DSP. Again, if the refusal is provided to our submission. The confirmation there are MRP place for the actually is already
Thereafter, there is an order on the 8th of February. No, no, no. No, no. No, no, no. That's time to time that permission has been granted. That's that apart. 8th of February 2022 is an order that there is no, you know that. What's that order? No, no, no. There is no provision has been made as regards implementation of the rules or for penalty of violation of several conditions which have been laid down in the rules.
Any violation of the orders issued under Notice 31 of the AIA is punishable.
How many FIRs registered? Now, please place it on record. Correct. Additional government advocate for respondents submits that in compliance of the orders dated 3rd of March 2022, the state government has framed the licensing and regulation of protests which have been notified on issued under section 31 within bracket has issued has what have you read? What have you written? Licensing and regulation of protests, demonstrations and protest marches within bracket Bangalore City bracket close order 2021 issued under section 31 within bracket 1 within bracket O of the Karnataka Police Act 1963. Full stop. It is further submitted that any person who is found to be violating the provisions of the aforesaid order is against any person who is found to be violating so and so provisions of the order. First information report is lodged and action is taken. Action is taken against such a person. Paragraph. How much time? However, press run is granted 2 weeks time to enable him to place on record the action taken for action taken in respect of violation of aforesaid order issued by the state government. List after 2 weeks.
Article 5, the Bharat committee. For a period of 3 years.
Rule 8A. Yes, Mr.
I was given a representation. The rule do not say that you can prevent it from anyone being worried. Due to any order to be forced on the government. Then no fault of mine. Then I'm entirely given ultimately for the extended effect to the week.
What do you say, Mr. Mehta? Will you no, will you seek instructions or what? Oh, file. Okay. When yes, so.
The statement was the intention taken in the statement of objections is not. Initially, my lease was up to 2016. From 22/3 2011.
22/3/2011 till
21/3/2016. After renewal service. Then when the renewal was pending, as the 10 groups existed, pending renewal members, there was a provision to extend the calling by 1 year. Till the orders are passed with the renewal of. During that stage on 16/8/2016, the rules came to be amended. But the rules provided that any lease was granted earlier will be valid for 20 years in respect of non-prescribed maintenance.
Yeah.
So my original lease was from 2001. So it was valid up to 2021. What was to be done was they had to exclude the supplementary lease deed because my lease deed had expired in 2016. They did not do so. Then because I filed a writ petition seeking for a mandamus that they shall exclude the deed. That order was passed by December of the court is at financial date page 457 in volume 2. Your article is volume 2. The order dated towards the 3rd of April 2019. WP 21040.
Yes.
That 457. I'm sorry, 457 is the order dated 4th of March 2020.
Yes.
But if you look at see, Act 416. The objection was it was a forest land and they were not permitting the quarry. But this one the court never ultimately hit.
460.
460 is operated.
We have it at 458.
But
Right,
it
para.
starts- It's order dated 4th of March 2020.
Oh, yes, 4th of March. Accordingly passed.
Complete the process of grant of deed extension in accordance with the schedule 4 of 8A. By issuing necessary order and by executing lease deed within a maximum period of 2 weeks, 2 months, keeping open the issue of applicability of section 2 of Forest Conservation. Because all of a sudden, in 2016, they started to dispute that it is a forest and though the area was being from 2001. But after that, pursuant to this order, my lords, they executed the following lease deed.
Mister, how much time will this take? Is it requires time? We'll take it up after motion hearing is sir. You are ready, no? Yes. Possible. Yes. Yes. Fine. So you have submitted the report, right? 24th February, BBMP. So what's this thing? You have taken. No, you have suggested some measures in your report. Respond number 10. Who is respond number 10? Who appears? You have to take measures, right? Mark the present. Let him respond. I mean, he should know what is it. We intend to implement. None of us is an expert dealing with. You are also not an expert, right? No idea. So they have this thing. They have conducted a spot inspection, and they have suggested some measures. So let a copy be supplied to respond number 10. Respond number 10 has to take steps, right, for implementing to prevent. That's why we are giving him next week. It will come up 3-4 days. Please supply during. What? Don't file objection. Mister, you are see. What is the petition about? What is the petition? No. Objection means you have to, because you are impleaded as respondent, so you have to oppose, right? No. So you have to create all sorts of hindrances to make the others' life difficult, because you are the owner of the property, right? Yes. Even if so, therefore you have a right to obstruct free flow of water and to create water logging situation and make others make life of others hell. Right? This is the argument.
My properties I have constructed. There is no natural channel or water.
Go through. That's why we said, you said we don't have the report. So we are giving you the report. Don't start with that. That's what we are saying, Mr. You. Why we are sitting here having in the public interest litigation is to find out a solution to the problem. It's not to be fought like this thing. He's not claiming ownership of your property, right? Not claiming. There is a no. This, what we are trying to tell you that you are appearing in a public interest litigation. The approach should be constructive rather than of an adversarial litigation that no, whatever they say, I will oppose. And I will prove that it's 2 a.m. in the night. So that should not be. Approach this thing, whatever the report, with a constructive this thing. See, examine the report with a constructive approach. Try to come out with a solution. Always be a part of the solution, not part of the problem. Right? That's what it is. Senate Council for DBMP undertakes to supply copy of the inspection report dated 24th February 2022 to Learned Council has supplied to Learned Council for respond number 10 today, who prays for short accommodation to enable him to go through the same and to argue list on. Go through the same, that's all, not argue. Which date? 19. Next Monday, 18 July.
May please, Your Lordship. I'm appearing for the petitioners, Your Lordship.
May it please
Yes.
the Honorable Court appear for Union of India, first respondent.
Your Lordship, there is the rejoinder needs to be filed, Your Lordship. Kindly a week's time may be granted in this matter.
So 18/4 also you were granted time.
Your Lordship, the instructions are sought. The instructions are
granted 4 weeks time to enable him to file the joint.
obliged, Your Lordship.
Inconvenient. Senate Council for the petitioner prays for adjournment on the ground that arguing counsel is not available. List after 1 week.
Appearing for the appellant respondent. I'm
Yes,
appearing.
Mr.
Milord, this may kindly be taken up next week. I inform Mr. Advocate on record as well as the senior counsel also.
So,
I inform Mr. Naganand also.
I only have a request.
20th.
Since he is requesting for time, he should not precipitate matters, my lord. There's an order, my lord, by which he should be reinstated as an archak. That should not be done, my lord.
I will advise, my lord, 1 week, not to precipitated. I can advise my client.
Please advise.
Court order need not be necessary.
No, we are sure that your client will accede to your request. Whatever instructions and advice.
I will.
Not request. Whatever instructions you will give, he will follow.
Yes, I
don't
certainly.
precipitate. Whatever. When do you want next week?
Any convenient day for the senior counsel, Mr. Naganand.
19th or 20th?
19th or 20th? 20th? Which day?
Very well, 20th.
Learned senior counsel for the petitioner pays for adjournment list on 20th July 2020.
Much obliged. Only 1 4 more.
52.
Madam, appearing for the complainant.
Ah.
My lord, a suit which we have filed on behalf of a society got a decree of injunction, my lord. The respondents in the defendants in the suit have filed an appeal before this honorable court. In RFA, my lord, at their instance, there is an order directing parties to maintain status quo. Your lordship will get that order at page 14.
A very difficult order to comply with, right? Status quo.
Now, my lord, in violation
Very
of
difficult to comply with the status quo.
they are page 57 photograph may kindly be seen.
Notice.
Very, I'm grateful.
Number 53, the Sundaresh HC. Number 54, the Ravindran P. Srimati Sri.
Yes, Miss, what happened?
Annex A.
What is it? They have filed a statement of objections. It is not ordered. Notice not ordered. No. Yes. Who has to comply? Respond number 1. 1 into both. What is the direction? You tell us, you have read it, right? Tell us, close the file. Issue notice.
Number 55,
Yes. Right. Learn it. Right. Issue notice to respond. You are appearing for which respond? 1 to 5. So say notice on behalf of 1 to 5 is accepted by Mr. So-and-so. Issue notice to respond. You, Mr. Patil, notice on behalf of respondent 6 and 7 is accepted by Mr. Vijay Kumar Patil, additional government advocate. Like below. Learned senior counsel for appellant as well as respondents 1 to 5 submit that there is a possibility of amicable settlement of dispute. They therefore pray for adjournment list after 2 weeks. Same order 55.1. Please see respondents and all that.
IFM not 56.
Yes, what? Password.
Lord, I appear, my lord, for the appellants 3 and 4. If it is passed over, it may not reach, my lord. Your lordship may hear me for admission, my lord.
Yes, of course. You are appearing for what? So,
an interim order granted and your lordship last occasion, my
all
lord.
right, we'll take it up today, Mr. Nagaman. We'll take it up. Please. Praying for a password. Let's see.
Number 57, the RP Somsekaya.
Yes. What happened? Issue notice.
Some 58, Sri Rajshekar, Devraj.
Huh? What? What do you want? Huh? You are appearing for respond number 5. Learned Council, mark the presence, mark Learned Council for respond number 5, praise for short accommodation to enable her to file wakalat. List on 14 July.
The 60, the Aditya Narayan.
Yes. Huh? Ah. Oh. All right, we are issuing notice. What? They. Oh. But you will agree. I mean, we can permit you to take out the hand summons. So this will, if we stay, it amounts to allowing the appeal itself. That's it. Yeah. Hand summons. Yeah. All right. In addition, issue notice. In addition, Mr. So and so is permitted to serve a copy on the Learned Council who represented respondents 1 to 20 in the petition before the Learned Single Judge. List on whatever date, 20th, 19th, whatever you want. 21st. 21st. List on 21st of July 2020. That's the point. By virtue of interim orders, they are continuing in employment. That's why we have issued notice. Yes. That's why without hearing you, we have issued notice. Yes. Let them appear. It's a case where which is to be heard. Huh? Password? Huh? Liquor license, yeah. But you respond to this, let's see. Same. Oh, what is that? WP number 11829. Oh, not see. You have heard what is he saying? Same order. Oh, petitioners are different. Yeah. Oh. Yeah. Yeah. We'll take it up along with that. When do you want? Huh? I will. When do you want? Fine. When do you want? Held up in other court. That's fine. You are held up here. He is in another court. Good. So what should we do with the case? Tell us. List for mark the presence. List for analogous hearing along with WP number 11829/2022 in the next week.
Pastor matter.
Yes. What submission? Yes. The office. Not present. Ah, yes. Elephant is. Oh, so they are necessary parties, right? Huh? Ah. Ah. What objection? You are fine. Fine. So, learned additional government advocate has said that the government would be happy to take care of the elephant, right? You don't intend to take care. Petitioners? No. You are a public spirited individual who doesn't want to do anything except filing petition, right? Don't be so serious, Mr. There's nothing. What is about the custody of elephant to the state government? They are ready, right? Don't be so serious. What is there? You are not the owner of the elephant. You don't want to do anything for the elephant. That's what we are saying. That you are an expert in filing public interest litigation, right? Yes, madam. What is it? Where is the elephant? Huh? Respond number 4. So who will this thing? No, but this thing issue writ of certiorari to cancel ownership certificate. Which provision ownership certificate is issued? What is it? I mean, we can't adjudicate, right? Title. So you are. So any appeal provided against that order? No. No, so you are the owner, right? Of the, then what is it? No, that's fine. No, what we are just wondering, section 42. Why then? Any appeal provided against this order? What I mean, we are just wondering, you are saying that question of title of elephant should also be decided in a public interest litigation. So that's why we are asking. How do we decide who is the owner? You are not the owner. Then no dispute with regard to ownership of the temple, that elephant. Then what is your grievance about the elephant? What is your grievance? It belongs to temple. So what? How do you know? How do you know? How do you know? What is the material to show that is not being taken care of? What is it? Shared with the petitioner by whom? Shared by the petitioner.
Petitioner has taken his picture and his video of the elephant that is presently being used for making on the street and we take a video and we use the elephant live. And in the objections that were coming from the temple, they agree to the fact that they do not have the facilities to take care of the elephant. And they do not have the funds to take care of it.
So this is a representation, right?
This is the
Or what else?
on basis of this representation, the department has also conducted an inquiry.
Oh.
They are able to
What happened to that inquiry?
The outcome of the inquiry has not been brought to.
Oh. Oh, where is that report? So you filed. We'll find out. Let her file the report. How much time, madam? Learned additional government advocate Pressfund is granted a week's time to enable her to place on record the inquiry report initiated. A report pertaining to the inquiry initiated in pursuance of the complaint made by the petitioner. Complaint dated 23/8/2021 made by the petitioner. List after 1 week. Oh, that order is there. Beginning you write permitted to retire. Office is directed to delete his name. Counsel for response. Yes. Your password was sorted in the first round. Tomorrow, day after, whatever. Ah. Eighteen July. None for the applicant. On a day after then. None for the applicant. Sultan Hulal and senior counsel for respond number. Respond number 1. Awaiting appearance of learned counsel for respond number appellant. Appellants, hearing is deferred. List on 13 July 2020. One minute. We'll just 5 minutes. We'll take it. Next. Any other password?
Number 56. The Srinivas Reddy happy.
I appear, my lord, for
Right. Yes. So before that, we'll yes take up your case. Before that, we will hear Mr. Panindra's case. It's one case.
Please.
And which other the password, Mr. That's all. Yes. Yes, Mr. Panindra. Yes. Mr. Mahendra, the prayer appears to be innocuous, or is it not? It appears to be innocuous prima facie before entering into merits, but you are contesting it, right? Okay. It's only to consider the representation. Execute supplementary deed. Fine. Yes. What is it? Facts, Mr.
Originally, the lease was granted. There are two dwelling leases. One is for an extent of 4 acres. The other lease is for an extent of 6 acres, 20 acres, so 6.20 acres. Because theoretically they were being granted and reserved for a period of 5 years each.
No, when these leases were granted to you?
Originally in 2001, the last of the renewal units that they submitted was on
22nd March. 22nd March 2001.
There are no disputes on these facts. For a period of 5 years, which expired on 21/3/2000.
When it was renewed?
22nd of March 2011
Ah.
for a period of 5 years,
Ah.
which expired on 21st of March 2016.
Yes.
But that filed my renewal application seeking renewal of the lease.
When?
But prior to the expiry, there was no dispute. Under the then existing Rule 21, I was permitted to carry on mining for a period of 1 year.
Application for renewal.
Yes, it was pending, but there was granted 1 year extension.
When were you on 22nd March 2016?
Yes, for a period of 1 year. Thereafterwards, again, because this one was rule. Because the rules were amended on 16/8/2016, Rule 8 laws. Okay, Karnataka minor legal concession rules came to be amended.
When? 2016.
12/8/2016, 12th of August 2016.
Yes.
But under which the rules stipulated that wherever leases were granted, renewal pending are deemed to have been granted for a period of 20 years from the original date. No renewals are entertained. That's the effect of the rule. I was entitled for a deemed extension from 2016 up to 2021 by virtue of the rules.
From the date of initial grant or what?
Initial grant 20 years.
20 years.
20 years from initial.
So like 22nd March 2001 you were granted, right?
Yes, yes.
It would be 22nd
March 2021.
21.
20 years.
Ah.
But because they were not considering the grant laws, deemed extension, I came before this one to go to in one petition. But the WP number 31973 of 2019.
Page?
We are working to get at page not 458, volume 2, correction J. In order that is 4th of March 2020. Volume 2.
Volume 2. Yes. 4th March 20.
Yes. But there, the lordship recorded the contentions to government that cannot be. But the government took a contention that the land was forest land. At moment, submission of the forest conservation act was not obtained. But the lordship directed, the directed to complete the process of grant of deemed extension in a period of 2 months.
So you are held entitled to deemed extension,
Yes,
right?
That was deemed extension was from 16 to 20. Pursuant to this, order of the Honorable Court, Dr. kindly goes to page 462. 460, there's the lease date copy.
Yes, query list.
Because it was finally extended on 6/5/2020 with effect from 22/3/2016. So where the retrospective extension was granted.
Up to?
Respect of one lease.
No, from which 22nd March 16 till?
Till March, it will be only up to March 21. The lordship, there is it's for a period of 5 years. The lordship sees the second.
Yes.
5 years. So 21st of March 2021 it would expire. In so far as the second lease is concerned, the lordship will get at page 538. The extra L on page will be a different page. 538 or 557. Extra L. 41/R1.
Yes.
That if your lordship sees, That is also executed on 6/5/2020 with effect from 13/04/2001 for a period of 20 years. Last facing page.
Yes.
But in spite of it, what happened was the state government still did not issue me notices to stop the quarrying operations and not to continue in spite of extension. I again approached this honorable court by filing another petition, which your lordship could get at running page 614 annexure M.
Annexure?
Annexure M number 614 in volume 2.
18/12/2020.
Yes, the beginning is at one page before that. An interim order came to be passed. Again, the issue was only on the forest, so they had stopped me from carrying on the quarrying operations, but this honorable court permitted me to carry on the quarrying operations. Also, it was open for them to adjudicate whether it's a forest land or a demand land. Because all the reviewed previous reports said it's a demand land.
Yes.
This period expired in March 21. Then Mallard gave a representation by referring to Mallard's speech. The lordship takes up rule 8A. The first proviso to rule 8A. Provided that the period of lease may be extended equal to the period if it exceeding 1 year for which the quarry remained closed, as known, due to court order or any other order by the government, and deterrent shall not be chargeable for such period. So there are two components here. One is when I am prevented from carrying on the quarry by the government or by the court. That period I am entitled for an extension. And what is deterrent is the minimum guaranteed amount which I have to pay every year, whether I work or not. So for that period also deterrent should not be charged. That's how they are given a representation at Annexure. They are saying that in view of this, from 2016 up to 2020, or 17 up to 2020, I was not allowed to carry on the quarrying operations because the extension was executed only in 2020. So there was a statutory deemed extension. So I have asked him to, I have requested him to consider this as a class non period, extend the lease period or grant me this extended period of 3 years when I was stopped from carrying on the quarry. Not to charge deterrent, I have already paid the deterrent. I asked for it. You have to either consider and pass an order. There is no application on this. But there is a chance to that. Being extension of 5 years, that's another provision.
Yes.
Five is number here, it was 355. Then the number has 735, 39 R1.
730.
739.
Ah.
Ah. This is to an extent of 4 acres is survey number 60 of Survey Benjamin. The initial grant was 22/3/2001 for a period of 1 year. Thereafter, on 23/3/2011, it was renewed for 5 years. And as per the provision law, then existed provision, it was granted, it was extended.
No, the submission made is only to the extent of consideration of his claim in the light of amended Rule 80 proviso, right?
These years are relevant. 22/3/2016, 21/3/2016. 22/3/2016. 21/3/2016. by the order dated 24/8/2016. As per Annex 1.
That is 21, right? 5 years. You are telling same dates. 22nd March 16 to 21st March 2021. What is it? Which date you want to tell us?
Not in the year 2016.
Ah.
1 year time was extended. That is from 22/3/2016 to 21/3/2017.
So that's you said 16. That's why there was confusion. Ah.
There are the petitioner has filed WP 21040.
WP
21040. That 21041 of 2017.
Yes.
Seeking the deemed extension of the particular date. For a period of 20 years. Then by the order dated 6/5/2020. Deemed extension was granted for a period of 20 years from the date of
Initial grant.
that is 22/3/2001 till 22/3/2020. But while granting deemed extension, the petitioner has paid all the dues, rent, everything. He has not raised any objection regarding this nice non-period, or that he has been prevented from carrying file operation. That was not the grievance of the petitioner in earlier two round of petition. So as other serious concerns. Initial file is number 360. We have been converted to 741 of REA. This is to an extent of 6 acres, 20 users. In the survey number, survey number 16. The initial grant was on 30/4/2001. 30th April 2001. For a period of 5 years. Thereafter on 30/4/2011, it was renewed for a period of 5 years. And on 30/4/2016 to 29/4/2017, 1 year extension was granted. There are two what the direction is by the 20 years deemed extension was granted from the initial date of release. That is 30/4/2001 to 30/4/2025. And my submission is in order to contend that he was prevented from operating from 16 to 20 or 17 to 20. He must establish that he was prevented from by the virtue of court order or by the order of the government. There is no such order preventing him from operating body. Therefore, my submission is provisional to ABA1 is not applicable. The deemed extension is granted under ABA4. The similar circumstances not in the case of complex mining industries versus state of Karnataka. They are prevented. The lessee in carrying out the operation. Then the remedy is they have to either civil suit for seeking damage for the prevention. That is one. So far as forest issue is concerned, it was notified way back in the year 1996. On 23 to 1931.
23 to 1931.
That's my love. Clearly narrated statement about
Yes.
But I don't know, is a major controlled under the UNDR Act. There is no such identical provision as now, as provided under the Civil Act. That is how their lordship said in that. But the only remedy is only to seek for suit for damages. Because here, not the rules itself provide for extension. To say that there was no prevention by the forest authorities, may not be correct because the repeated orders. So then also because if your lordship seems volume 2, though I do not want to drag your lordship to the merit, but the endorsement issued by the forest department, the lordship just comes to volume 2 page. One document, 2020, 684 AP. It's an AP. It's a letter dated May 6, 2017 by the forest, forest.
97 or 47?
9/6, 2017.
9/6.
Just before 2007. There seems to be a little page number.
9/6.
Yes, sir. It's a letter of disclosure to the developer, referring to our own leases. Where they said do not permit foreign leases to not be granted. The forest department was the one which was operating and never allowed to work from 17 to 20. Now all these they have considered, but there is no adjudication on the request itself.
Only inter-departmental communication.
Which shows that I was prevented. Ultimately, my only endeavor is that I was prevented. They did not execute the supplementary date within the time. Till 2020, they never executed. So I have benefit. So,
Yes, give that judgment. Make copies. Only these two files. Let's see. It was 45. 40. No, 40.
I appear not for appellants 3 and 4. Not the appellants before your lordships, my lord, are the landowners. The dispute, my lord, relates to 1 acre, 2 guntas of land. It's not just in the outskirts of Bangalore, so it's a somewhat valuable property. Our clients, my lord, though on record it appears that possession was taken, but in effect it was not taken because they had houses and they were living there. That is evidenced, my lord, by recent photographs also. My lord, they challenged the acquisition, my lord, in an earlier writ petition. That, my lord, was dismissed. Against that, a writ appeal was preferred. And in the writ appeal, my lord, the Honorable Division Bench, while disposing of the writ appeal, made certain observations. If your lordships could kindly, my lord, take page 225. The order begins at 225. That's the Division Bench order. Or kindly go to page 258. Lord, the contention was that this land was acquired and 5 acres was allotted to respondent number 3 for the purpose of setting up a hospital. That was the main defense which they urged. And they said that hospital is a public project and it is a part of an infrastructure. And the single window agency, my lord, had granted this land for a multi-speciality hospital. If your lordships could please, my lord, notice one sentence at page 252. First line on top. It is in this background. The third respondent approached. 252, my lord. Right on top, first line. It is in this background, the third respondent approached a single window agency with a request to grant about 5 acres of land to establish a multi-speciality hospital. Along with the application, third respondent enclosed a memorandum of association, articles, etc., etc., and they give all the details. Now, my lord, please go to page 258. Para 27. Yes. Acquisition of land is for setting up a multi-speciality neuro hospital. We quite understand that when the total extent of land is 5 acres and 5 guntas, 7 writ petitions were filed challenging the acquisition. Now 6 writ petitions are disposed of. It has attained finality. The possession of 4 acres, 3 guntas of land is delivered to third respondent. Please note that. Remaining 1 acre, 2 guntas, which is a subject matter of the appeal, once it is handed over to third respondent, they should be in a position to implement the project. Unless the entire extent of land is handed over to third respondent, they cannot think of putting up construction. The pendency of this litigation before the court is cause for delay in obtaining sanction of the plan and putting up construction. As all persons who are involved in the company are doctors of high repute and financial institutions have come forward to extend financial benefit, once the land is made available to them by the board, we do not see any impediment for establishment of the said hospital. But nonetheless, next sentence is somewhat important. That's what I rely on. But nonetheless, once the land is acquired and possession is delivered to third respondent, the third respondent shall use the entire extent of land only for the purpose of setting up a hospital. In fact, the said land is to be given to them on lease cum sale agreement. If there is any violation of the terms of the lease or if this land is used for purposes other than putting up a hospital, KDB shall cancel the lease, reclaim the property, and the benefit of this acquisition shall not be given to the beneficiary. Keeping in mind the object behind the acquisition, the object with which the third respondent has been formed, and above all, keeping in mind public interest, persons who are going to benefit from the hospital, this acquisition is upheld. Next sentence, my lord, is also kindly noticed. If the object is in any way diluted or not given effect to, third respondent would not be entitled to the benefit of the acquisition. Hence, we pass the following order. This order was challenged in my lord, a writ appeal before the Honorable Supreme Court. Page 261, my lord, is the interim order granted. Your lordship may notice the date, my lord. It's order in SLP number 9662, and the date your lordships will get in the first page, left-hand side, my lord, about 7-8 lines, 18/3/2013. Kindly go to the next page, paragraph to page 262. After issuing notices, in the meanwhile, parties including petitioners are directed to maintain status quo with regard to the subject land in all respects. Then, my lord, the matter was heard and the Honorable Supreme Court, my lord, was pleased to dismiss the special leave petition by order at page 264. At 265. Now, my lord, the operative portion of the order passed by the division bench, I gave, my lord, a representation as per Annexure T at page 305. In which, my lord, I point out all these facts. This is, my lord, Annexure T 18/3/2020. The reason why, my lord, this was given was, if a lordship, my lord, returns page 367. What they did, my lord, during the pendency of the stay order of the Honorable Supreme Court was in operation. They approached the single window agency for change of views. And that your lordships will get, my lord, at page 369. This is the minutes of the single window agency. Proposal of Messrs. SSSN Projects Private Limited. 5 acres so and so. Multi-speciality hospitals, RD, R&D, along with support services as hotel, health club, etc. Last column, my lord. Amendment sought change of land use from multi-speciality hospital to IT park in 2 acres of land at Bellandur village, so and so. Now, whether this could have been done at all is a question that I raised, because there was an earlier order of the court which specifically said this is upheld only for this purpose, otherwise they will not have the benefit of the acquisition. In the face of this, what they have done, my lord, is completely wrong. Then, my lord, kindly go to...
When was this granted? Date?
This order, this proceeding is dated 15/6/2019, my lord. What your lordship saw now, 15/6/2019. It is during the pendency of the interim order grant of status quo. Then, my lord, this company passes a resolution at page 267, whereby they say they want to carry on real estate business. If your lordships would please turn to page 267. Amendment of the objects clause. Page 267, annexure N. Right on top, my lord, 4th line, your lordships will get the date, 11th January 2018. Again, at a point of time when interim order was in operation. They say, my lord, that they are amending, kindly see amended object number 1, to carry on and engage in the business of real estate, such as buying and selling of plots, land, and to undertake work of land development on individual joint development.
So,
and joint...
what is the interim order you want at this point of time? It's on admission.
Yes. The interim order, my lord, I'm respectfully asking is this. My lord, what happened was that based on this approval, they filed, my lord, they gave a complaint to the police, and the police, my lord, came and demolished the whole thing on 7/5/22 and made it into flat land. The photographs show that our family was there. The land is, my lord, now barren land is kept like that. So that should not be, my lord, they should not do anything with the land till your lordships are pleased to hear the matter. Is my respectful request.
No, but your apprehension is that they will construct this thing, right?
Yes, they will. They now, we understand, they have now entered into an agreement to sell this to some real estate person. And it is that person who is behind all this. Very innocuous letter they give to the police. The KADB gives to the police, and the deputy commissioner. When the position is, the Supreme Court says maintain status quo, there are structures there. Based on that, on 34, they give the letter. 7/5, my lord. They come with 200 policemen. The photographs are on record. They demolish the building. All our domestic things are thrown out. Ladies are driven away from that place. Then, my lord, this allottee files a suit in vacation and obtains an ex parte temporary injunction to say restrain me from interfering with their possession. This is nothing
what is
but
that order of injunction?
Yes, that order of injunction, my lord, is 12/5/22. After the demolition is done, everything is, my lord, demolished and made ground level. Then they move a suit. OS 312 of 22. In that, my lord, on an ex parte interim orders granted on 2/6/22. I have entered appearance and I filed application. I have also filed a contempt petition, my lord.
12/5 or 2/6. What is the date?
The actual date of demolition is 7/5/22. The order is dated, my lord, 2nd June 22.
Wait.
2nd June 22.
2nd June.
Yes. OS 312 of 22.
Okay.
It's
Yes.
also on. But I have also filed a contempt action to say that when the Honorable Division Bench had directed that if hospital is not built, the KDB is directed to restore the property back. That is what the direction is. They have violated it. They have not taken any action. I given representation as per Annexure T to point out you have to obey the division bench order. They have not done that, whereas they have gone ahead and permitted this. Meanwhile, one more real estate transaction has taken place.
Yes, you are appealing for?
Even that petition also disposed of in the direction they saying that you have to construct hospital. It will be on 7th they came as per the order of the single judge, they came to the property, they gave the possession with the order saying that you construct hospital.
So what is the change of land use? Why did you seek for land use? Change of land use?
Everything has been considered even by the Supreme Court as well as by the order of the single judge have challenged now. Everything has been considered in that, and they told that the representation of the petitioner can be considered. That should we have to know. I am not saying anything. I am not saying nothing.
No,
I am
give.
following the appeal order. I am also following the Supreme Court order. So based on these order.
File an undertaking. File an undertaking. Please file that you will consider hospital only. Then we will see. File that. Orally saying is not good enough. File. When will you file? Tomorrow. Yes. We'll take up this Nagan tomorrow. Yes. Learn it. Mr. S.S. Naganan, learned senior counsel, and Mr. Vikram Puligol, or two learned senior counsels for the appellant. Third, on the question of admission, learned senior counsel for the appellant submitted that the acquisition proceeding initiated by KIADB in respect of land held by the appellant were upheld by a division bench of this court by an order dated 22/11/2012 in WA number 1735/2007 with a direction that the respondent number 3 shall use the entire land for setting up of the hospital only, and if there is any violation, the KIADB shall cancel the lease, full stop. Paragraph. It is further submitted that respondent number 3 now intends to indulge in real estate business. It is also pointed out that special leave petition, namely SLP number 9662/2013, has been disposed of with the liberty to the appellants to pursue the remedy which may be available to them. It is also submitted that the appellants had filed a writ petition before the learned single judge seeking a mandamus to decide the representation dated 18/3/2020 in accordance with the directions contained in the order dated 22/11/2012 in WA number 1735/2007, and to withdraw the land acquisition proceeding. However, learned single judge has directed to decide the representation submitted by the appellant, and has not dealt with the grievance of the appellant with regard to withdrawal of the land acquisition proceeding. It is also urged that the action of respondent number 3 in putting the property to commercial use for what is it? Real estate development for development of the IT park is contrary to the directions issued by division bench of this court. In view of paragraph, issue notice to respondents. No, don't say issue notice. Notice on behalf of respondent number 1 and 2.
One is state, my lord, two is KADB.
One is accepted by Mr. Vijay Kumar Patil, learned additional government advocate. Who is a madam? You are appearing. Mrs. Vani, learned Srimati Vani, learned additional government advocate for respondent number 1. All right. Mr. Chandrasekhar, Mr. P.V. Chandrasekhar accepts notice on behalf of the respondent number 2. Office is directed to reflect his name. Mr. So-and-so accepts notice on behalf of respondent number 3. He prays for short accommodation to enable him to file an affidavit stating that the land in question shall only be utilized for the purposes of construction of a super specialty hospital. Place tomorrow.
Would it be on Friday, my lord?
Huh?
Would it be on Friday, if the lordship pleases.
Friday?
Some difficulty to.
All right. Fridays. 15 July.
Great.
What interim order? He said
they should not change the nature of the
Oh, no, just a minute. We don't know, but learned senior counsel for the appellant submitted that the construction has been demolished and whatever it's in possession of what. No, but there is a order of injunction in your favor, right? No. Arey, Mr. Wait. We are not doing just. Mr. Ravi Shankar had appeared on the last day. There is no order. He is not right in saying because he doesn't know. Mr. Vikram didn't appear. He doesn't know what is the order. Mr. Nagaran knows. Mr. Ravi Shankar himself volunteered that I will not do anything. That's what there is no order. Huh? So we are taking it up on this thing, right? 15. Whatever you don't carry on till next date of hearing. Whatever. What? Of course. So you place it on affidavit tomorrow. Mr. Nagaran, let it be tomorrow or day after if you can. Tomorrow, day after any missing. We have recorded your submissions, right? And we have. So we have to only hear.
See if I can join, or otherwise my.
Tomorrow, day after when?
Tomorrow itself.
Tomorrow. Undertakes to file an affidavit by tomorrow. List whatever tomorrow. No. We later when we said you are not there, of course. Mr. Naganan that appeared, and Mr. Ravi Shankar said that he will not. That's the order. There's no order. Please file an affidavit tomorrow. What about?
End of charges number 62. Please wait for that.
Oh. After disposal of mark the presence, learned. Who assistant commissioner, learned. learned counsel from the parties jointly submit that that in pursuance of the order passed by the learned single judge dated 2/8/2021 and 16/8/2021 passed in WP number 15077/2020. An appeal has been filed, an appeal has been filed before the Assistant Commissioner, Bangalore Taluk. Full stop. It is further submitted that on 23/3/2022, the Assistant Commissioner has stated the recommendation of the Proceedings of the Land Grant Committee. Full stop. In view of aforesaid subsequent development, the contempt petition is disposed of with the liberty to revive the same in case occasion so arises. Yes, Mr. What is it? PIL? No, not PIL. Green bench. Green bench. Your appearance means green bench. Huh? Yes. Okay. What happened? The petitioner also must have forgotten about the writ petition, right? Huh? 9. What is it? Issue a demand notice 8/4/2009. There is an order, right? Saying the demand. So subject to deposit of 50%. So how much time is it? Do it? Go through this. What is that? An additional government advocate prays for short accommodation to enable him to prepare the case and argue the same. Yes, on 19th. Please go through this. 19th.
The 64, CH Nagaraj.
In serial number 64, I appear for second and third respondents for both the cases.
Devi Gunja. Ashok Naik.
Yes. Yeah. Huh? Oh, so we are looking for you here somewhere, standing by the side of petitioner, and you are also petitioner, right? Nothing. He is telling us what are the facts. You also go through the file. Let him be in court hall 20. You are in court hall 2, right? So see the file. What is it? Yeah. What is it? Yeah, yeah. What 12 acres? Ah. 19 acres and 10 gunta. 12.
And 22/9/1963, government acquired land nearly about 30 acres for the development of this land. Okay.
So this was acquired for tank.
In survey number 11/30/102
What happened to this in construction? It was it site to whom? Huh? Huh? Oh, you have made our job so easy. Huh? Okay. Huh? Oh. You have a competent junior to assist you. Why did you come running? She would not have allowed anything to happen, right? What is page? Please give them copy. Page 16. Yes. What is it?
The present application, second petition, you said dispose of this petition. Apart from the petition was no action, so the lead petition is connected matter, so I dealing with such petitions. This could extensively dealt with the issue related to the patient mediation of vacant state. The committee headed by 3 pages of this honorable high court. This is the appointment to deal with the issue, proper resolution maintenance of the vacant state. The extensive review was made by the committee. Detailed report containing several documents were filed. But disclosing the petition number of clients and other client factor against the missing number. So the director proper essentially should be erected on the day. The court directed the buffer zone and the 30 meters should take around all the lanes maintained and directed to remove unauthorized inspection. There was somebody as many as 11 directors should have been put. 31.
No, so what is it? What has been done? No, you will take, there are 7 pages, you will take time. What is, tell us, what is it? No, if you start reading, there are 7 pages. We are asking you, what is it? What has the court done? Operative portion following.
Around the lake, my lord, second measure 30 meters. Any construction within that can be removed, this can be saved. We are not against anybody. We want the lake to be saved.
Yeah. What has the court done? One minute.
directly to go for this state because it's applicable across the state.
Yes, Mr. Please see. Have you got this copy of this order?
Lord, I appear for Lord KIDB. Lord, copy of the order is not appears to have been given just now. I may have to go through the Lord order. But as the things stand, if I may submit my Lord.
If you will take it up tomorrow, you go through whatever. Please go through the order passed by the division bench of this court. Please go through it.
Yes.
We will take it up tomorrow.
Please, boss. Please.
Tomorrow, please go through, Mr. Please go through the order. We will take it up tomorrow. It will continue in the list, right? So please go through this order. Yes, yes. Big. Yes.
There's a one the bigger like at the downgrade. This is the larger target. I mean, there's a natural terrain of the water the higher course. Now the construction is going around this large and then the lake bed. That is it.
Right. Direction. Please go through. Tomorrow we will take it.
In fact, there is a report, my lord, of the deputy commissioner, which says that Lord, we have not formed any layout in the tank bed, nor have we made any allotments.
We want map also, na? All right. No. Fine. Oh, their map. That's what. No, we don't have any problem hearing it right away. You said that it has not been supplied. Therefore, if you want to argue today, no problem. Tomorrow. Yes. No. Fine. Yes.
My lord, I am appearing for petitioner in this matter, my lord. So I am praying for 2 weeks time, my lord. Senior going to engage.
No, senior is not going anywhere. 12 years.
We are going to engage senior council, my lord.
Don't engage any council.
Please, my lord.
12 years. After 12 years, suddenly you wake up from your slumber and want to do something. We will not permit that. 12 years.
Already we have engaged, my lord. So he has for last 2 years.
Senior council is never engaged to seek an adjournment, right? And nobody in this thing accepts. No senior council, we are sure, will accept a brief so as to enable you to make a prayer for adjournment. Nobody does it.
Please, my lord.
Don't argue. What is it? 12 years have passed, nothing, nobody is interested. Go ahead.
My lord, kindly pass out for 10 minutes, my lord. My senior will come to online.
What? How senior will come?
No, my lord.
You are going to engage a senior council.
Senior council is not present today, my lord.
He will come.
So he will make submissions, my lord. So
no. When will you make submission?
So
you. No, forget senior council. We want you to make submission. When will you start making submissions?
Definitely will make, my lord. But
definitely. When? Not this year.
Definitely this year, my lord. Today is not possible. So
today not possible. Why? What happened?
No, my lord.
No. We are asking about you, not about senior council. Why you should not make submissions today?
Please, my lord.
Nothing. What is it?
My lord.
Password. You get ready tomorrow. This is 12 years old petition. Tomorrow, please. No adjournment.
Please, my lord.
Yes. What? Right. You should supply him a copy of statement of objection, right? Filed by them. That's right. Please supply him a copy of statement of objection. But you supply him statement of objection, right? Call it tomorrow. You give him copy of statement of objection. Let him go through. Yes, tomorrow we'll take it up.
Government educate. Yes, sir.
My lord, in this case, I appear for the petition hearing. In this case, my respectful submission before this honorable court.
Which case?
From the
67.
Please, my lord.
Yes.
A week's time may be granted. I will present my case.
Wait. Oh, the junior counsel had just disappeared, right?
Please, my lord. Please, my lord. My colleague only appeared in serial number 65 also.
67.
65 also my colleague appeared. Here in this.
But 65 is tomorrow. This case we will grant you adjournment because it's 2015 petition.
My lord, my submission, respect to submission from the beginning.
There is a property dispute, and we have to call RA, which is pending before the Supreme Court. So I think there is the arbitration 13/6/2019.
13/6. Mr. Mitra, see 13/6/2019. What is the order? What does it say?
There is a decree in Civil Court which forces the
right. So RA is pending. So what?
RA is pending till the certification of that RA this was required. That is why it is pending.
In the light of order dated 13/6/2019, hearing of the petition is deferred. Therefore, list the parties are granted the liberty to mention the matter as and when RA pending before the district court is decided.
The case hearing, the position of law regarding these regarding environment, whether it was exceeded prior to 2011 or
All right, we'll continue tomorrow. Continue. Tomorrow we'll continue. Which case? 69. Further status report. Further status. Mr. Vijay Kumar Patil, Learned Additional Government Act, paid correspondence number 2 and 3. Grace fund is granted 2 weeks further time to enable him to file status report. 69, right? Yes. Remaining cases will continue tomorrow.
With your lordship's leave.
Yes.
May I mention item 71?
71. Yes, please.
For the rest of the week, I have some personal inconvenience. Would your lordship kindly would your lordship kindly have it next week?
Yes. Yes, sir. 19th July. articles. The senior counsel for the appellant phase for accommodation list on 19th July. 19th.
Please.
Yeah. Okay, you are appealing with Mr. S. Vijay Shankar. Hmm. 78. Repeat, sir. Repeat. Parties have granted liberty to mention the matter as and when regular appeal pending before the district court is decided. Matter as and when the regular appeal pending before the district court is decided. ಮಧ್ಯಾಹ್ನ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ, ನಾಳೆ ಡೇಟ್ ಇರೋದು, ಕಳಿಸ್ತೀವಿ, ಸೈನ್ ಮಾಡಿಸಿ ಕಳಿಸ್ಬಿಡಿ. ಡೇಟ್ ಆಯ್ತಲ್ಲ, 63 ಮೇಡಮ್ 63 ಅಂತ ಒಂಚೂರು
1.508.
ಮಂದಿ ಯಾರು ಕೊಟ್ಟಪ್ಪ ಫೈಲ್ಸ್? ವಸಂತ್ ಕುಮಾರಿ ಅಂತ ಇವರು ಚೇಂಬರ್ 63 ಫೈಲ್ ಇವರು. ಅವಾಗ ಹೇಳಿ, ಇವಾಗ ನೀನ್ ಬಂದಲ್ಲ ಅದು ಬೇರೆಪ್ಪ, ಅದು ಅಂಬಿಕಾ ಅವ್ರದ್ದು. ಇವಾಗ ಒಂದಷ್ಟು ಫೈಲ್ ಸಿಕ್ತಲ್ಲ ಮಲ್ಲಿ, ಓ ಮಲ್ಲಿ, ಅದು ಅಂಬಿಕಾ ಫೈಲ್ಸ್ ಬೇರೆ. ಇವಾಗ ಈಗ ತಗೊಂಡೋದ್ನಲ್ಲ ಮಲ್ಲಿ, ಕೇಳಿ. ಈಗ ತಗೊಂಡೋದಲ್ಲಪ್ಪ, ಅದು ಯಾರು ಕೊಟ್ಟೆ? ಈಗ ಒಂದಷ್ಟು ರಾಶಿ ಇತ್ತಲ್ಲ, ನೀನ್ ಬಂದ್ಬಿಟ್ಟು ತಗೊಂಡೋದಪ್ಪ. ಅಲ್ಲೇ ಜೋಡ್ಸಿದ್ಯಾ? ಪುಣ್ಯಾತ್ಮ, ಅದು ಮೇಲ್ಗಡೆ ಕೊಡು, ಅದು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. ವಸಂತ್ ಕುಮಾರಿ, ವಸಂತ ಅಂತ, BKV. ಆಯ್ತು ಅವರು ಅದು ಬೇರೆ.
ಸರ್
ಹೇಳಿ ಸರ್.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 70.
ರಿಪೀಟ್ ಸರ್, ನಾಳೆಗೆ.